This conference is being recorded.
Good evening, ladies and gentlemen. This is Dave, Ed, and Michelle. Quite a show for you tonight. Bring your pad and paper and pencil and take some notes, because I think tonight will be an enlightening experience for you. And with that, I will turn it over to Ed for his comments. And then Michelle has a very, very interesting document for us tonight. And I think you'll all get a real bang out of this one. Okay, Ed.
Thank you. Anyhow, we'll get to Michelle in a few minutes. I want to get a couple things started and straightened out here with the craziness of fools. But let me first off and saying we would like to thank you. We're glad that you're able to listen to us. We are the Lawful Americans. We are the Lawful Bloodline Americans, as copied and filed. And I've been filing that in the House and Senate of Oregon going back to 1992. So it's been copyrighted in my instruments. And it says that in my introduction when I pass it out to everybody. So that is the main point, is knowing the truth. And you're going to learn one thing this evening, how these people that are out there getting people into trouble because they don't have authority. And I'm going to end up starting the one thing I want to put into effect with Dixie and Ronnie Davis. Ronnie Davis was a so-called continental judge. There is no training for these continental judges. There's no training for the marshals. All they do is get these guys sworn in and let these guys go out to the world and get in trouble, and then they go, well, why did you do this? You're supposed to know this. Or why didn't you ask permission? Number one, a continental judge, if you look in the European nation structure, continental is European nation. Continental marshals are European nation, not U.S. marshals. There is a big lawful and legal difference. Remember, your federal government is the British government, and they're under contract of 1871 after the Civil War. That's how we ended up with the contract, so that when BLM, Bureau of Land Management, was installed, they were supposed to keep land records for lawful Americans. Okay, read the BLM charters on their structure of BLM. Don't take somebody's word for it, and don't take me for it. You have to sit there and do your research so you know the truth. And this is the point that with a lot of people, I mean, with our templates that me and Dave will put out, you know, and I don't like to call them templates. I like to put them out, and you guys have to write your own structure. You have to take responsibility for your actions. And that's the point, is knowing the difference of lawful and legal. Dealing with one of the arguments that is going on in the conversations I've been having, or the internet talk I've been having with some of these people, is very interesting, because now they're trying to claim that, 20 years and one generation has rights, and there was no lawful Americans in this country for 100 years. Well, number one, that's the most moronic statement and moron statement I ever heard in my life, because you're going to say the natives haven't been here for 100 years? I mean, this is the point that gets to me with people. Our country goes back years. The Constitution was a contract with the world, so we had freedom against the Roman Catholic King James Bible. Because if you go back in real history, if you did not convert, and especially in the 1400s, 1492 is the big number, if you didn't convert to Christianity or the religion of that country, you were beheaded or tortured to death. You know, and this is what gets to me. You know, Dixie sat there and put us on a conversation one evening, which was very interesting, with Bruce, trying to claim that lawful Americans that she started and claimed a couple of months ago, and she said in the deal, I claimed it. You claimed my copyright. That's a fact. And if you got a problem with that, you call the United States Federal Marshals and you ask them. Okay? Impersonating a federal officer is a federal crime. To make sure you guys are aware of this reality. Okay? I'm just so frustrated when I sit there and watch these people put this stuff out to the general public, claiming this stuff. And the thing that gets to me is that nobody is really standing up against some of this fraud that is being portrayed on people. Now me and Dave, and now I'm standing up on it because after going through this stuff because of what the attacks with Revolution News and Radio for the last 8 months, and I've witnessed this stuff, I lived this stuff, I've been involved witnessing this stuff with my comments back and forth on this stuff. Now, we do have people that got wrapped up in a lot of people's bullshit that are coming back and making apologies. So, and then when we accepted a couple apologies from people, oh my God, these other people went off on us going, you shouldn't accept the apology, you should condemn them to hell and all this stuff. Excuse me, wake up. I don't care about your religious beliefs because the First Amendment says that you're entitled to believe in your religion in your home, in your structure. That's what it was in place for. Not that you can sit out there and try to push your religion on the rest of us in our country. You come to our country, you leave your stuff in your country because you come to our country to learn our rights, our structure. So that way you can pass it on to your bloodline to be free. You can't just come to this country like Obama and Hillary and the Democratic Party has been claiming since, what was that bill that Bill Clinton passed in 1992, the Immigration Act that was bullshit? Don't forget, Hillary Clinton passed the Children's Act that was able to sit there and, steal your children without a trial. Because prior to that, they had to take you to a jury trial before they could sit there and go after you. You know, and that's the point. This is the point that is a true structure. Okay, our forefathers put this structure in so we had rights. And those people who are sitting out there using 192 and all this other structure that are immigrants, I'm waiting for the day of reckoning.
What about your headphone?
Go ahead. You want to speak up? Go ahead. 970, were you trying to say something?
No, not me.
Okay, well, I was just wondering if they were talking in the background, please mute yourself. We appreciate that. No problem.
Sure,
I mean, we don't have to mute you. You can mute yourself. We you know, that's the whole point, that we've got to work together in these things. Oh, *6. Thank you. I need that correction.
You can also, on your phone, you can mute your own phone.
Mm-hmm. You know, that is the point. You know, I mean, and if you don't sit there and start learning the correctness of your standing in court, when you go to court, you have to know if you're lawful or legal. Okay? And this is the point that most people do not comprehend this fact. All right? Because immigrants, you cannot just be born here and say, I'm an American. And that's why all these people are so upset and attacking me and Dave, because we have a lot of immigrants, and finding out, doing some of the research with some of these projects that these other guys are doing, some of these guys are from, other countries. You know? I mean, and this is the point. They're from other countries doing this to us. And there's a lot of these guys that are doing this stuff who are not Native Americans, and so they don't want to be deported, so if they can throw confusion out to everybody, this way they think they're saving themselves. And I'm waiting for Trump to start this deportation structure. And I get so sick and tired, and I've argued with people on talk shows and on the internet, these poor babies, you can't go after the poor babies because it wasn't their fault. Yes, it is their fault because their parents did it to them. They need to blame their parents. When are people going to be adults and take responsibility? You know? This is a point that is so frustrating, you know, that it's just so amazing, that it's so frustrating that these men and women will sit out there and sell a product to you guys, and put, your name in it so you're in trouble. That way you go into it. Like I said, Ronnie Davis had his, I'm not trying to slam Ronnie Davis at all. I want Ronnie Davis, maybe someday he'll open his eyes to some of the stuff because he didn't want to listen. Like he came on our show a couple of times and try to actually take control over a talk show. And the thing is we're not allowing that type of stuff to happen because we have to take a responsibility and take our country back. If you don't take your country back and have responsibility, all right, for yourself and your children and your responsibility, you can't blame the rest of the world. You can't go for sympathy and say, we need to do this and you should have compassion because I did that and this. I have compassion when it comes to Native Americans. I even have compassion when it comes to immigrants, so long as they do it legally, lawfully to legally. Okay? And that means 5 or more generations. And like this Byron Parker keeps going, well, you have improved the structure. Yes, I have. We've filed it. And this is the point. It is not statutes and codes. And it's like I get this one guy saying, I don't think Ed knows the concept of corporate slavery. I know more about it than you do because you guys are still in it. It's like these judges and so-called continental marshals. Ask them. Bruce even admitted it on talk shows 3 times. 3 times. That he buys insurance and driver's license. He complies with this, that, and the other thing because the fight is more important than being in jail. Okay? I've got people that I know right now today who drive or travel without license plates on their vehicle, who have their stuff filed in the county structure, done it lawfully. Okay? But they're lawful Americans. They're not legal citizens. And this is the point that we want to get democracy back to England. Democracy has no place in the United States of America. We are a Republican form of government by the constitutional structure of every state when they did that. And if you read the original history and the original structure that goes back in this country, that's the way it is. We went to Civil War so we weren't paying property taxes. We went to war so we weren't being slaves anymore. All right? We didn't have any structure of taxes in this country, at least I know from the West Coast, till basically the 1980s and 90s. Okay? I know. I lived it. I fought it. I've been on the actual fighting grounds on this structure. And so it's so disturbing when I see this, when people say, Ed, many immigrants are legal. They are legal. They are legal citizens. They are not legal Americans. And you are not American bloodline. Yes, I am, and that's in my contracts, and it is recognized by the state of Oregon and the feds, William. So just so long as you know, everything that I file and what I do is on the Senate floor, in public media, and also to the FBI, CIA, and every department, especially the marshals, get it. Because I have nothing to hide. I'm not ashamed to stand up for my country. I'm not ashamed to sit there and tell people, if you don't like my country, get the hell out of it because we don't have to have compassion to you. Okay? I grew up in the Bay Area. We went through even some of the so-called fights on this growing up, This is the thing that disturbs me is that, most of you folks were not in the fighting field or playing in the field. Most of you folks were watching TV, living games, and playing your structure. You weren't in the game. Most of you people didn't open your eyes up until the last few years. And so that's the thing that gets to me. You're going off of things you don't have true knowledge of, okay, and you have a concept of it, okay, but personating public servants, and this is a federal crime. Okay, and that is the point. You have to realize this is a federal crime on these things. Okay, now the thing that sort of disturbs me, and I will say it dealing with Ronnie's attitude and his outbreaks is probably what got it, because sometimes he doesn't react rationally. And it's like, we all been there. We all lost our temper. We all done this. I'm just amazed of some of the structure that Ronnie got himself into. I've watched the tapes with Ronnie and other people that he was working with, doing this, going after that, saying these things, and it's like, the thing is I'm going through this on the internet right now with people with smart meters, okay, with smart meters. You've got to realize that they don't have rights to put a smart meter on your home. I've got a template doing. I never had a smart meter until they chased me around the state, literally trying to murder me, that I have on record by the district attorney, filed in the Oregon State House and Senate last year. Nobody disputed anything I said on record, including the district attorney that was there at the time, Rob Yvette, who was part of the assassination attempt on me, to cover up because they put all these drug programs in. What is that called? For the drug programs for democracy, because my attitude, if you're claiming that you're a drug and alcoholic idiot, you're giving up your responsibility so you can sit there and whine and try to plead for forgiveness. And people sit there and go, well, it's not my fault that I did drinking. It's not my fault that I did this or that or the other thing. Yes, it is your fault because you put it in your body. Because of whatever transpired in your life at that time. All right? You had a bad experience, because anybody who recalls the first time they had a drink or the first time they ever smoked the dope or joint, okay, hemp, okay, that it was a happy time. And then after that, everybody starts doing the depression dance. They do this depression dance. Because all of a sudden I lost control. Well, the thing is that you don't sit out there and publicly make an ass out of yourself like that. You make an amends. You get your shit together and you make amends to the people you hurt. That's not where you go publicly and sit there and go, oh, I need to do this and I need to do that, and it needs to be public. All right, so you violate your first, fourth, 15th, or your first, fourth, fifth, seventh Amendment rights. So you violate it. And that's the point. You're violating it. Wake up to the truth here. Because wake up, who's doing what? And yes, we all went through things in our life because of lack of knowledge, with lack of education. Nobody could blame one another for going through a bumpy road. We all been there. And that's the point, is that we all have been through the bumpy road. We all been there, and the solution is how do we get out of the bumpy road? And so the one thing that Dave and I do is that we speak and we talk about the actual laws and administrative rules that are created by, yes, the de facto system of the contract of 1871 and the Administration Act, the first one of 1889. So you go back to 1871, the other contract, because remember, the British government, democracy, has been trying to claim that they own this country for the last, a couple hundred years, but every time they've been defeated. Even when they did that with the bankruptcy. That's why House Resolution 192 became in place, because lawful Americans were forced into paying gold that they thought and silver. When they did the Bankruptcy Act, and if you actually do some of the research, it was supposed to be for immigrants and the public servants that abuse the system. And that's the point that people don't realize. They don't read this stuff. They don't go through in-depth history, especially like what me and Dave have literally done and Michelle have literally done. I mean, we're opening up things because of our knowledge and education, and we can see these points of what's going on. And without that, you guys, we don't have a future in this country. And I agree. We need to shut the borders down immediately. We need to find out who's legally in this country. We need to find out if they have a record, and if they do, the first thing is ship them out immediately. I have been in court cases where I witnessed immigration people walk away from murder, causing bodily harm, raping children, raping teenagers and women. Watch the judges release them and let them go out the door. And they do that, folks, because that's how they keep the industry going. Because without the so-called de facto system that we're living with, the flag that's in the courtroom, the tribunal flag that's in the courtroom, They couldn't make the industry money that they're making and bankrupting our country by we the people doing it. This is the point, bankrupting us. And they figured they couldn't beat us in war, so now they got to try to bankrupt us. And this has been going on since the Administration Act of 1940. You know, and don't forget, all immigrants that are not registered with the 1938 Foreign Administration Registration Act, read it, you can be deported. And they are getting that, and I'm glad to see it being changed. And the other point has been proven, and we already know Obama is not a legal man in this country, or even a lawful man in this country. And so I'm waiting for the other indictments to be filed, because everything that man's done in 8 years shall be overturned. Democracy is not part of this country. All right, you have responsibilities to yourself, not your neighbor, not to the church, not to the homeless programs. And if you want immigration, like I always tell people, and I've been saying it since I was a young man, if you want immigrants, you take care of them, you feed them, you clothe them in your own home. We're not going to pay for them. We're not going to pay the taxes for them. It's not our responsibility. Oh, that's right. Taxes are a fraud in this country to lawful Americans. And if you actually read the structure, and lawful Americans, and that includes Indians, because that's this part of the structure, because a lot of us are half-breeds or quarter breeds, whatever you want to call them, okay? We still have the rights, and it says in the law that we're not liable to pay taxes. And that has been proven in all courts. But see, the thing is getting these men and women to honor their oath of servitude, and this is what I say to people. You want to go for a minute, Dave? You there, Dave?
Yeah, I'm here.
So anyhow, let me finish up this. So I'm going to turn the floor over to you, and then we're going to give it to Michelle. But I want to get my little statements out, because I get so frustrated with these guys from foreign countries trying to dictate to us how to live in our country. I mean, I made a terrible mistake, and Dave knows this, that, you know, I assumed that this one guy was going to help us out in his book, and I never realized that he was going to be taking this information and spreading it around. So, and no, I've watched it. I see what's going up on, what do they call that? Lawful American site. Sorry, we're lawful Americans, and that site I've been using. And you guys just came up with this after doing it. Now you guys want to fight with me, Dixie, and all this stuff when you claim our site is yours? And then you're sitting there going, oh, we're going to have Bruce call you. All right, Bruce, let's go to federal court. Let's go deal with it. Let's go see how well you know the court with your degree. All right, this ain't a game. But I'm done with court. I'm tired of attorneys like yourself that are sitting there, you know, oh, I have registration, I have insurance, but then again, you're telling people how to do this stuff, but you're not willing to back them up. You're not willing to put your money or your freedom where your mouth is. I don't have driver's license. I don't have that structure, and I've never been involved in a lot of that structure my entire life. And it's known through all the agencies. No joke. And I say this publicly. I've been in the Senate and House hearings. I've been involved with a lot of people up in those type of structures, arguing, approving this structure, and everybody keeps trying to say, how do you expect to pay for the roads without paying property taxes? Excuse me, folks. Property, gas taxes into gas prices, and trust me, the money is there. Each state, and Oregon in 2005 and 7, somehow miraculously came up $500 million short. They don't know where the money was funneled. The IRS just proved that they had $9 trillion just fell out of their budget. It's amazing how all these agencies are losing our public money, because when you actually talk to a real elected official who knows it, the money and assets of this land belong to the lawful Americans. That is a true fact, and that means over 100 years. That's in Congress, in it. We own it. Their job is to collect the resources to pay us under the Banking Act. Okay, that's a fact. But then they say, we're not going to give that money back to you, because this is true. I have this on record, too. We're not going to give the people the money because we can spend it better, but we're creating jobs for you. Number one, all right, well, you're creating jobs. You're cutting down the trees and timber. Oh, you want to go and say, oh, there's a climate change. Well, we've climate changed this coast from the east to the west coast in the last 200 years, where all these foreigners came to our country, cut our trees down, and sent it all to their home countries to make a living, and our deer and elk and our food resources, our buffalo, our salmon, our trout, our native food, deer, and I'm talking squirrel. Squirrel's good eating. Raccoon's good eating. I've eaten skunk too, but you got to know how to prepare it. Thank God I didn't do it because I didn't know how to prepare it, but it wasn't bad. You know, I've eaten a lot of these wild stuff that people would not even think about eating. But I made sure I had to eat this stuff in life so that way I knew the truth about things compared to what people are saying. Yes, I've had rattlesnake, alligator. You know, I mean, the thing is that we can't sit there and assume. And that is the problem with assume. And when I sit there and watch these men and women out there and start putting people in jeopardy, you know, I mean, it's interesting because, I mean, I've watched these guys that sit there and file it, and I'm going to jump back on Bruce for a minute. And I know I'm going to end up leaving all the Bruce structure and all this stuff alone because it's going to come in time. But when Bruce came to Oregon, I spent almost 2 hours on the phone with him before he came to Oregon. And I'm talking to him about filing criminal charges. This is before Lavoie was murdered. And how come nobody's filing criminal charges on these men and women? And all I hear is, oh, no, we got to form a grand jury. Oh, no, we got to do this. And I'm like, you can't do that without criminal charges because when you go to court, folks, when that court opens up and you have no evidence of proof to prove your claim against them, why do you think they win? You prove it. Now, there's people right now who are going back through appeals courts that are getting things overturned because they filed paperwork. I know personally of cases where people filed affidavits where the woman went after the man and tried to put him in prison for, you know, not paying child support or this. And the guy has a affidavit says, Your Honor, here's the way it is. You see this? And the guy goes, yeah. And a guy went through this a few months ago that told me what he was going through. He told me, and I saw his stuff, and I said, this is what you need to do. And he did it, and the judge dismissed the case. He proved the woman was lying. If he didn't have the affidavit, he would have done 5 years in jail. So in an affidavit is fact, because there'd be a lie in an affidavit that's perjury. Now, we know we have a defective court system that was placed in place, but we're supposed to have responsible and lawful Americans running it. Now we got judges from other countries in our system, and everybody goes, oh, they're legal. They were born here. If you actually read the Constitution, and when Dave gets a chance, let him do it, and then we'll pass the floor to Michelle. But when you read the Constitution, it says this stuff. And then people go, well, it doesn't say it in the Constitution. The Constitution is a one-page structure that Hancock put out to the world. No harm, no injury, no foul. You commit a harm or foul to somebody, you are liable. End of story. Now, it doesn't mean sticks and stones, you won't make brain bones, but names will never hurt me, because that's true. You can swear and cuss at people and all that. Sorry, if you don't like emotions, leave, because I don't want to hear how your feelers were hurt. Because if you're not a man or a woman, how do you sit there and stand up for yourself? And I'm going to, before I put the floor over, clear one thing that I argue with people about. A woman's body is a woman's right, because a woman has an equal constitutional right as a man does. Now, other people say a book says to do this, but how are we supposed to honor mother? Without the woman, you're not alive. Period. Male or female. You know, test tubes, they've already proven how that works, and some of the things are going on that's not totally public, but, you know, they've got test tube people that have been around for 50 years, and if you go back in history, the first test tube structure was done in the United States and Germany in 1901. Do your research. You know, that's why I tell people when I talk to them on the phone before I get involved in a lot of their structure. You know, I want to know what they know before I get involved, because I'm not putting my butt on the line for them. But if they're starting to be realistic and starting to catch on it, and I can start seeing that they're actually proving to themselves that they're doing stuff, I don't have a problem slightly getting involved or suggesting to people my points of view of what the wording might be. Because you have to learn the wording to these people. And its wording is that they kidnapped my child. They stole my Grand Theft Auto to my car, Dixie. When you called into our show, oh, my car was stolen. Well, if you're a marshal, and how come the judges didn't teach you how to file and do that stuff? like Dave said to you. You know, I mean, all we hear is the bitching from people that are not doing things properly. And let me tell you, the judges do know if you're lawful and legal when you go in the country. Trust me. You know, these agencies do know what lawful and legal is. Yes, they'll ignore you because otherwise they can't justify their income. But the minute you make a real standing and it's known, they don't bother you. They have respect for you. And that's the point that we need to get back with each other so we have respect for one another. And when we're dealing with immigration or immigrants, that they have privileges. We have to know the separation of lawful and legal in this territory. 48 states. 48 states were bounded in the structure of the constitutional contract of 1871. That was the first structure of money implicated across the country and stuff. We had 37 banks until, across the country, because everybody had their own inflation rights, their own structure of what they were purchasing. And that was done until 1933, the Executive Order 2040, and it didn't get implemented until 1940 under the Administration Act. So anyhow, I don't want to waste a whole bunch of time on these guys are trying to create an argument and they're trying to steal our structure and saying that they're lawful Americans because they were born here from another country. Or an immigrant has an American. No, you're not an American until you're fifth generation. Read your immigration papers. Oh, not the ones that they changed from Bill Clinton. Go back to the 60s and 70s, the 50s, the 40s, where it really said it in the paperwork. They changed and altered paperwork. I mean, I watched a lot of bills and structure changed in the state of Oregon in the West Coast. And they leave out a word in the law, or they leave this out, nobody responds in 3 or 4 years, and they take another one out, nobody responds because they don't get it. That's how they've been dropping and changing stuff through the lawyers in your House and Senate and your, what do they call that, legislative council. So, anyhow, it is doing some research and knowing what it is compared to what we're led to believe. Anyhow, I'm going to pass the floor on to Dave, and then we'll let Michelle speak, and then we'll get to some questions, too. Anyhow, Dave, the floor is yours. And thank you, folks, for joining us, because the main point, if we don't sit there and protect each other and know the lawful and legal difference, and that means when you have somebody that's going to court, you know, and if they're an immigrant, yeah, we can protect them, but we need to know the standing of what they're doing and how to do that. There is a legal and lawful difference in our court systems, and trust me, the Senate and the House knows it, the FBI knows it, the United States Marshal knows it. These guys truly know it, but it's when you argue with them, they like argument. I know. I used to be in that position. I was glad to get out of it because I couldn't sit there and do some of the rape, robbing, and pillage of some of the stuff. Anyhow, and I won't do that, humiliate my soul that way. Anyhow, Dave, the floor is yours. Thank you.
Okay, Ed. I want to get into Michelle's stuff right away because this, like I said earlier, grab your paper and pencil and take notes here, ladies and gentlemen, because you're going to find out some things that you've never heard before. And this is how fraud by trickery they have tried to ruin the Constitution for the United States and the criminal acts against we the people. So take and pay attention. Michelle, the floor is yours.
Good evening, everybody. And yes, I can understand Ed's frustration. It is hard when we're trying to address the facts on true evidence and not try to deceive anybody by those facts regarding how we're being tricked and how we've been deceived over many years, not just by our presidents who are in office or who's been in office just recently, but actually by many of our presidents throughout many years. And I also want you to know that I'm not a lawyer, I'm not an attorney, but I have done my homework. And so I'm going to reveal to you some of the things that I have discovered, and of course you're going to also take notes. And I'll give you some information so you can also look up this information yourself and read it at your pleasure. First, I want to start out by saying there's you can write this down, and it's under prose and professional, and that would be dash. So you would say prose, P-R-O-S, and professional, P-R-O-F, dash, C17200. Now, you can put that in Google search, in your Google search bar, and you will come up with what that means under C17200. So that's a statute and a law that you need to learn. Also, I'm going to kind of go over some bits and pieces as to, based on history regarding our Constitution, and how you can apply the Constitution to your lawful rights when it comes to pinpointing these parties that we're up against, meaning our state senators, our governors, our president, all lawyers and attorneys, and of course our judges. You have to understand, when you use the Constitution to your advantage, that means get your book, that little template, because those amendments to the Constitution pertain to the laws that are there for your legal rights and for your protection when it comes to addressing your unalienable rights in court. When you apply the statutes and the codes, like Ed was saying, statutes and codes are not law, but what they do is they define the law. But what has happened is our lawyers and attorneys and those that are addressing the law, what they're doing is they're using trickery, and they're defining the law unlawfully. In other words, they're not really telling you what the truth really is pertaining to certain laws. And if you don't know those laws or those codes pertaining to the true meaning of that law, then that's where you're going to be deceived in court, and of course that's where you will lose. Because it comes down to principles. The principles pertaining to the law and knowing your constitutional rights. I'm going to start out by, there's something that I had put together regarding information. But before I get started, I want to give you an email, because I would like you to look up this stuff and read it for yourself. And then what I would like you to do is get back on the call next week, and let's go over some of those questions and answers by what you've discovered by reading these documents yourself and how you've been deceived. Keep in mind, you're going to be quite shocked. I was very devastated by some of this information, because I couldn't believe myself how I was deceived, and knowing how we were all deceived by our own parties in our government as to the branches of our government pertaining to commerce. So what I want you to learn and Google at your leisure, and that's called Barefoot's World. Now, this is a gentleman who addressed the Constitution, and he had put information together regarding the Constitution and where you stood knowing the laws pertaining to the Constitution, and how you were also being deceived by those of our appointed members regarding the branches of our government as to what has been going on. So it would be www.barefootsworld.net, then / original, and then .htm, and I believe it's a small l. So that, or if you just Google barefootsworld.net in your Google search bar, you'll also get the document. It'll come up. It's a website. Now this gentleman, oh sure.
I'm not able to get. Is it Bill Foot's World?
No, bear, like the bear, B-A-R-E. Barefootsworld.net.
Barefoots, like a foot.
Yep, that's correct. F-O-O-T-S. Barefootsworld.net. So if you go Google that, what you will find out is it's a gentleman who addressed the Constitution for many, many years. Now, he had deceased, but because he did such an awesome job putting his research together, they would not remove his work. in honor of what he did. So they left that there for those that are searching the laws, searching the truth pertaining to where you stand under the Constitution, and also understanding the Constitution, because many people get confused. So that is what he did, and I come across his website going back to 2005 when I was looking up laws and also addressing legal issues as to what I was learning. Now, I'm going to, before I go into what he addressed in that document, by the way, when you pull that up, you'll get a 6-page summary, and that is what David was referring to. He wants me to get into it and talk to you about it, which I will do. But there's something I want to read to you that I had put together that will kind of help you understand where Ed is coming from as to where we stand as private people, as private sectors pertaining to our Constitution. So I'm going to read something to you, and then if you have any questions after I read it, by all means, I'll try to do the best I can. This was something I did up, and I addressed it as a courtesy notice because, after all, I wasn't suing anybody, so it was kind of like a courtesy notice, like, in other words, how you would tell somebody, here, I want you to read this. This is something that has to do with true facts regarding the law. So, in other words, you were giving them heads up. This is what you need to know. So it's called a courtesy notice, and it's unduly verified declaration of facts. Biological precedent. A lawyer is a person who knows the law, Black's Law Dictionary, and other. It is said that all persons are presumed to know the law, meaning that ignorance of the law excuses no one. And then, of course, I cite the statute. Therefore, all persons are presumed to be lawyers. Now I go on to say, by Christian principles and logic. The highest social law is the golden rule, quote, do unto others as you would prefer them to do unto you. And then I cite a verse out of the Bible. Equity, Black's Law Dictionary, daily living of the golden rule is the highest practice of the law and is necessary for a stable society. Such practice of law cannot require a license or compels to conclusion that every man who professions or lives by the golden rule is a lawyer. When men is denied assistance to counsel to practice his certain unalienable rights, endued by his Creator and secured by the Constitution, this weakens his position as a citizen, thus weakens the country as a whole. This is giving aid and comfort to the enemy, treason. These two civil rights laws mandate that we help others in need by legal advice or otherwise help when we understand the law, to protect our certain unalienable rights endued by our Creator and secured by the Constitution. This, if anyone attempts to charge us with practicing law without a license, they are then violating our civil rights and may face federal criminal civil rights as a felony charge. And I cite the statute, which is 18 U.S.C., Section 241, Section 242. Under Title 42, U.S.C., Section 1985. Pertains to a conspiracy to interfere with civil rights. 1. To prevent an officer from performing a duty. 2. Obstruction of justice. Intimidating party, witness, or juror. 3. Or depriving persons of rights or privileges. Under Title 42 U.S.C. Section 1985, action for negligent to prevent conspiracy. Every person who, having knowledge that any of the wrongs conspired to be done, and mentioned in the in the preceding section, which is under 42 U.S.C. Section 1985, are about to be committing or having power to prevent or aid in preventing the commission of the same, neglects or refuses to do so, if such wrongful act be committed, shall be liable to the party injured, or reasonable diligence could have prevented. By our failure to take positive action, we shall be just as guilty as those taking our freedoms away from us. All people of good will make mistakes, even public officials, but they will correct their mistakes and never take away our freedom. The First Amendment, citizens' lien against treason. So I'm going to give you a little bit of an explanation here, because I hear about taxes, or what the taxes are supposed to pertain to. Our taxes were actually supposed to...
whoever has not muted out, please do so right now. I hear a child running in the background. So please, if you either mute your phone or *6, okay? Thank you. Go ahead, Michelle.
Our First Amendment citizens' lien against treason. Now, just so for those that don't know much about the law, what that was applied to was when we, as people, or even a citizen or a person who violated the law, for instance, the taxes regarding the corporate side now, not on us, but the taxes were supposed to be there, put in place for those that had committed a crime. In other words, you would get a reward for if you were a victim pertaining to a criminal act. The taxing would be money that would in other words would be put aside to pay for your damages rendered. So the First Amendment citizens' lien against treason. Consequence of filing under 18 Section 4, any judge, attorney, and or other court officer using the court system acting under the color of law who violates his/her required oaths to support the Constitution for the United States of America is violating the soldier's oath to support and defend against all enemies, foreign and domestic, thus is committing rebellion and incarceration against the authority of the United States, which authority is the Constitution. Therefore, the judge, attorney, and or other court officer is committing treason. 5 U.S.C. Section 3331, Oath of Office. In an individual except the President, elected or appointed to an office of honor or profit in the civil service or uniformed services, shall take the following oath. Now I'm going to cite these oaths, and I'm going to pretend like I would be one of them. As I, Michelle M. Christensen, do solemnly swear or affirm that I will support and defend the Constitution of the United States against all enemies, foreign and domestic, that I will bear true faith and allegiance to the same, that I take this obligation freely, without any mental reservation or purpose of evasion, and that I will and faithfully discharge the duties of the office on which I am to enter, so help me God. The second, the judicial of office, originated with the Judiciary Act of 1789 and continues as a requirement under 28 U.S.C. Section 453, but was amended slightly in 1990. And it states like this: I, Michelle Christensen, do solemnly swear or affirm that I will administer justice without respect to persons, and do equal right to the poor and to the rich, and that I will faithfully and impartially discharge and perform all the duties incumbent upon me as Michelle Christensen under the Constitution and laws of the United States, so help me God. 18 U.S.C. Section 2382, Misprisonment of Treason. Whoever, owing allegiance to the United States, levies war against them or adds here to their enemies, giving them aid and comfort within the United States or elsewhere, is guilty of treason and shall suffer death, or shall be imprisoned not less than 5 years, and fined under this title, but not less than 10,000, and shall be incapable of holding any office under the United States. Now, I'm sure a lot of you listeners are probably saying, yeah, right, well, I got news for you. Now, that what I just read to you, that's where they are committing treason upon us under secrecy, of course, and I'll go into that later on. But now I'm going to cite this. It says 18 U.S.C. Section 2383, Rebellion and Incarceration. Whoever incites, sets on foot, assists, or engages in any rebellion or incarceration against the authority of the United States or the laws thereof, or gives aid or comfort thereto, shall be fined under this title or imprisoned not more than 10 years, or both, and shall be incapable of holding any office under the United States. The Constitution criminal complaint process we utilize is the citizen's First Amendment right of the people peacefully to assemble and to petition the government for readdress of grievances. Did you catch that? That's where the taxes pertaining to our corporation is supposed to go to. Judges and or U.S. prosecution attorneys in any court system cannot lawfully attack our liens against treason, which any citizen files against federal judges, U.S. prosecuting attorneys, and required constitutional oaths for the Constitution of the United States of America, without shutting down the selective service of the military. Our liens are more specifically called casual public commercial lien against treason. Notice of the existence of a First Amendment administrative commercial lien process of the United States of America. And of course, now, if you were to cite that and you had a case pending, or you were going to take a case upon the court, then that's where you would put your date. In other words, that you're going to use against them regarding this lien, and you would put that date there as to when you were addressing the court. A constitutional public commercial lien is. Now I'm going to cite what a commercial lien is. A commercial lien against a public officials violating of their required office oath, which is equal to the military oath, to support this nation and its Constitution against all enemies, foreign and domestic. This lien is supported by the filing of a criminal complaint. Now, for those that don't know the law and don't know how to address the court, a lot of times what you're doing is you're taking your cases into court civilly. A lot of times you have a criminal case. Unfortunately, they don't want you to know, that you should file a criminal complaint. Because remember, when you file a criminal complaint, it's not you now taking it into the court. It's supposed to be our state that takes it into court. And they look into the violations that they have broken and where they violated your rights or your due process rights. and is also a commercial lien against the public official's rebellion, incarceration, or treason committing against the nation of the Constitution, and also is consequently a commercial lien against the public official's violation of the natural and civil rights of freedom, life, liberty, and the pursuit of happiness of the people of the United States of America, and is also a penalty against the public official's failure to provide the necessary, proper, and lawful officials for substituting false, fictitious, and fraudulent services, and is also therefore to provide restitution and rebate of the taxes back to the public as an exercise of the First Amendment, right of the people peacefully to assemble and to petition the government for readdress of grievances, and that's where you petition the court, to guarantee just compensation for taxes. This Constitution shall be the supreme law of the land, and the judges in every state shall be bound thereby. Anything in the Constitution or laws of any state to the contrary notwithstanding. The U.S. Constitution, Article 6, Paragraph 2, see also Amendment 5, Just Compensation. The military soldiers who are serving this nation, losing their sanity and their body parts, shedding their blood, and dying on battlefields, presumably to protect and defend the nation and its Constitution against all enemies, and serving to protect our freedom, liberties, and pursuit of happiness, and serving to protect the soldiers' own future and their families' futures, are being cheated out of justice in the courtroom system, as is happening today to the public citizens. Internationally, an administrative commercial lien process contains a very curious grace period of 3 months. The Jewish is 90 days statutory, in which the defendant's lien debtors party receiving this commercial lien process can contest the commercial lien claim of commercial lien categorically point for point, if they feel or believe that any part of the administrative commercial lien process is false, fictitious, or fraudulent. The 3-month, 30-day grace period allows ample time for the defendant, lien debtor, to expose the commercial lien claimant's claim and commercial lien claimant to the strict remedies of commercial law. Enough time to discover and reveal whether or not any party of the commercial lien claim is false, fictitious, or fraudulent. Upon refusal or filing of the commercial lien, defendant's lien debtors to fully contest the commercial lien. Are you there? Hello? Hello?
Yeah, we're here, Michelle. Go ahead.
Okay.
We're here.
Okay.
Everybody's here. We're here, sister.
Okay. It sounded like I got disconnected. I'm sorry. Commercial lien becomes active as an account receivable, collectible by marching and seizing, also known as debt collection. The grace period can be extended for reasonable cause. It is painfully obvious that if the officers and agents of an all-powerful government have not contested the commercial lien within the 3-month, 90-day grace period, then it must be because its public officials and or agents cannot contest the commercial lien without exposing their own fraudulent behavior, incompetent behavior, or criminal behavior, let them prove otherwise. When the government's public officials, officers, and or agents dishonor the administrative grace process by contempt or other default, they waive their legal and lawful ability to claim that the administrative commercial lien process by contempt or other default, they waive that their legal and lawful ability to claim that the administrative commercial lien process is false or fictitious or fraudulent. Now I go on to say, notice to public official, officer, and or agent. Should you disagree with or contest any part of this International Administration Commercial Lien Process document, you must immediately show by affidavit sworn to be true, correct, and materially complete and not misleading under your own commercial liability, your specific just cause of findings of facts and conclusions of law to support your contesting of the administrative commercial lien process. Failure or refusal to contest this administrative commercial lien process shall be construed to mean that you are in total agreement with all points of this document. As I, Michelle, exercise the right to amend this and or other document if necessary in order that the truth be more fully and certainly ascertained and justly determined. Notice to agent is notice to principal. Notice to principal is notice to agent. Therefore, as public minister, as Michelle, a wife of an ex-military, a civil rights advocate, C, acting as non-union lawyer, not a member of the Bar Association, President 242 U.S.C. Section 1985, acting with reasonable diligence of 18 U.S.C. Section 241 and Section 242, protection of the nation, its Constitution, and our civil rights. Public minister, present to and protected by Public Law 94-583, da-da-da-da-da. I'm not going to cite all those because it's too many. Codified in 42 U.S.C. Section 1985. Now, please see attached exhibits. That's my exhibits. We'll pass over that. But then I say this message on declaration of facts, on evidence regarding this fraudulent claim that's been brought forth by the plaintiffs herein under this foreclosure complaint under prose and profession, C-17200. The plaintiffs have indeed been in contempt of court. Now, for those, I'm sure you know what that means when someone says that they're in contempt of court. Now, when you apply contempt of court, that means that they're in violation of the law or they have broken the law. So you would use that terminology as contempt of court, or if they have not responded to you within the 90-day grace period, etc., they would be in contempt of court. On their own actions and have indeed been in contempt of court for violations for not following through on their own motions as being way overdue by the 12-month or whatever, 90 days, 30-day grace period as to the summons. So I'm going to skip over that because I want to go to things that you need to learn. And then I say I now come and move to take, or excuse me, I went too far. Hang on a minute.
Excuse me, Michelle, can I add something to that?
Yeah, sure.
Remember, folks, when you do a commercial lien, you have to notify the people involved or the petitioners involved of a commercial lien. If you don't notify them and file it with your clerk, it doesn't exist. Anyhow, thank you.
That's true. And that, now keep in mind, I'm talking about a criminal complaint, but that is true. If you're going to file a lawsuit, you have to you list your defendants. If you're the plaintiff, you would list them as the defendants. If you're the defendant and you're listing them as the plaintiff, vice versa, you have to list the facts as to where they're violating your due process rights or your rights under the law. Now, one thing that's very simple, we always focus on the big stuff, but we don't focus on the little stuff. Usually when you, if you're a defendant, for instance, and you get a summons, the first thing you have to do is you have to file a motion to dismiss for lack of jurisdiction, and for them, in other words, for them being in the wrong, or for bringing a fraudulent claim upon you, or whatever pertaining to the evidence. I mean, it's hard for me to answer those different types of cases because every case is different. But you would file a motion to dismiss if it's a claim brought upon you that is fraudulent or partially fraudulent on the facts. One thing that's really important, first of all, we forget to use the Constitution when we cite our laws when we're addressing the court. So what we do is we're so focused on citing our laws and statutes as to where you're finding fault pertaining to your defendants. But what you forget to do is you forget to add the Constitution to them. And another thing, you want to add case laws to your facts pertaining to what you're trying to prove. When you cite your Constitution and your facts pertaining to the under common law as to certain cases that have already gone to court, and you can use that as evidence, and you also bring evidence in, trust me, the judge is going to look at you like, whoa, hang on a minute here. I'm not going to be so quick just to dismiss this case, because then you could file a motion against the judge for being biased. One of the things that's real important is a conflict. Whenever there is a conflict between the law, for instance, if they're bringing something into the court and you know that they're not being truthful when it comes to citing a law, that would be a conflict. Now keep in mind, you're going to use the Constitution to your advantage on that, because see, anything that's a conflict to the contrary against the Constitution is null and void in court. So it doesn't take a whole lot to say to that judge, sorry judge, but I object, there's a conflict here. There's a conflict pertaining to the Constitution. See, when you use the Constitution to your advantage, and you subpoena the court, by the way, you can tell them that you petition the court, not subpoena the court. You petition the court, and you put that judge on notice that, first of all, they're addressing you in the wrong jurisdiction, because they're not supposed to be taking you into court. You're supposed to be going into court under a common law grand jury. So there again, they violated your rights, didn't they? So that would be your number one thing. I'm sorry, but I have to file a motion to dismiss due to the fact that the plaintiff brought a claim upon this court, and you got to look this stuff up, you got to learn how to say certain words certain ways, but you would dismiss it due to the fact that they violated your due process rights, they violated the Constitution, they violated the laws pertaining to the Constitution, therefore I move for a dismissal. Then you wait for them to answer. Now here's the good thing. If they don't answer, don't bitch. In other words, sit back in your chair, be quiet, and wait. Because if they don't respond to your request, then you can file for another motion, which would be a motion of default, or another motion for a motion to vacate, and go after them. Because now you got control. Because they would be in contempt of court. So it's good that they don't answer. Now I'm going to go back to what I was reading. So now we go into when a person stands to gain advantage from playing both sides of the street. Now that's another saying. In other words, you're telling the judge that, well, geez, wait a minute, we got a conflict going here, because we have in other words, how do I say that? In other words, we'll take the Democrat and the Republican. If there's a conflict going on between the two, and they're converting with one another behind secrecy pertaining to you, that would be a conflict. That's a conflict of interest. So in other words, what I'm trying to say is if they were playing both sides of the fence or both sides of the street and you didn't know anything about it, that would be a conflict. Because they're not supposed to do that. Okay? That would be illegal. A promise for a promise. Every contract, whether written in ink with the formalities of seal and witness, are merely spoken in a private meeting between two persons, is an argument in which promises are exchanges. Thus, a meeting of the minds, breach of contract. If such exists and can be established as a fact upon the record of the court, there will always exist a cause of action. The contract, though you may have to bring a lawsuit under a cause of action, e.g., trust, theory, or quotum on the merits. Okay? Let me go on. I'm going to skip because I didn't really... Oh, that's about it. Okay. So then we have the writ of mononymous, which is a writ. It's an order. A government official or he or she is acting in a particular situation or requiring such person to act in accordance with his or her lawful authority. Thus, if the mayor of a town refuses to convey, the city council or a aggrieved citizen can move the local court to competent jurisdiction to issue a writ of anonymous requiring the mayor to act as accordance with his or her legal fiction, or take it upon him or herself to act as a judge and jury, directing the local police chief to act. Please explain by what that. Okay. Now, what I'm doing there is I'm. You have to understand. I'm putting the court on notice. I put this judge on notice, and so basically, what I was telling this judge, hey, they violated the law. They violated the Constitution. So you can petition. You can actually petition your mayor to come in and act as a judge, a sitting counsel, regarding your grievances pertaining to you. Okay? Okay, now, probable cause.
May I?
Yes.
Is that a writ of mandamus?
Yes.
Okay.
I'm sorry, I was saying it wrong. Thank you for correcting me.
Mm-hmm. You're welcome.
Yes, that is correct. That's what I meant to say. So that, and you would do that. Now, you would only do that is if you had the evidence to prove what you're claiming and to prove that they actually are bringing forth a fraudulent claim into court upon you. And in other words, you have the evidence to show that what you're claiming and why you want to move for a motion to dismiss, and of course, and why you're asking for the your mayor to come in as the sitting judge because you feel that that there was many violations pertaining to the court that violated your due process rights and da-da-da-da. I mean, there's a lot there to learn if you ever go that far. So anyway, that's what now probable cause, of course, is another thing because that has to do with an IE examination of all the rulings of this, meaning the lower court proceedings and the proceedings of your case as to the lower court or higher court, in other words, violating rules, grievances, and da-da-da-da-da. It goes on and on and on. But we're not going to get into that because that's not really what we're here for. But now that was something that I wrote up, and I had actually sent that document not to court. I actually sent it to the state attorney's office. In other words, I was putting my state attorney on notice that, hey, do your job. You took an oath to protect my rights, and in other words, you're not protecting my rights when it comes to your oath. So let's see now. Hang on a minute. I'm going to pull up another form. Some things here I wanted to go over before I go into the goodies regarding the Constitution. Oh, that was an affidavit of truth. Now keep in mind, when you do an affidavit of truth, remember, when you address an affidavit, anything that you say in that affidavit better be true. Do not speculate and do not lie, because I'm telling you right now, you can go to prison for making false claims when you address an affidavit. So keep that in mind. And also, an affidavit has a lot more power when it comes to addressing the court. That's why judges don't like affidavits. I'm going to read something. I was working on a document. Actually, I was helping Ed with. I want to read something because this is kind of something that might kind of help some people that are trying to understand how we're being deceived and what's going on. First of all, I ask that you learn your Constitution. You also learn about the True Bill, meaning the Bill of Rights. Now, there's an article you can look up. It's called the True Bill out of Washington, D.C., which would be UCC, and that's doc number 2012114776. Now, that has to do with the Declaration of Facts pertaining to the Bill of Rights. I would recommend that you look it up and use it to your advantage. It also has to do with the title of nobility, which is the 13th Amendment. You should know what that means pertaining to the 13th Amendment, why they removed the 13th Amendment, and of course now many people are discovering why they removed the 13th Amendment and really what it meant, what it pertained to as to the Constitution and your rights when it comes to the 13th Amendment. But this is something I just kind of did up, and I want to, because this has to do with the Constitution. In other words, this is how we, the people, would write this verbiage or use this verbiage as if you're going to challenge the court. So you say, Your Honor, I now come before you by the giving name, and of course I would say Michelle Christensen, and then I would say, here before this honorable court, I am an unfranchised, common law free man or woman who lives under natural law. Then you go on to say, Counselor at Law, now known as petitioner, because you always petition the court, okay? Remember, you're not supposed to, when you petition the court, they can't charge you for court fees and costs. When you pay court fees and costs, what happens is you put yourself in their jurisdiction. That's why lawyers and attorneys will not take you on as an assistant, because they want to get you into their jurisdiction. And they won't do it because if they do, then they're violating their oath to protect the Bar Association. That's why they won't take on, or they won't allow you to hire them as an assistant. There's nothing in the law that says hire. That's BS bullcrap, but that's what they claim because they want to get you in their jurisdiction. Anyway, Counselor at Law, known as petitioner, I am not a participant in any taunting scams, limited of liability on a joint venture of profit with an unanswerable interest requiring me to participate in these illegal corporate Ponzi schemes. I am just your average Joe Blow from Joe Blow from Claremont, down the street, and live, work, and travel at common law, also known as natural law. Counselor at Law, right to work, add on, a workman is worthy of his heir, and I have a right to work and contract my labor and my skull and my time of life as I see fit, not as some third-party, arbitrary, and co-precious bar association who sees fit. I am standing as my own, as counsel I have appointed myself as my own attorney, and I am ready to proceed in my administrative and procedural matters. This petition, affidavit of truth, now comes before you to witness the fraudulent intent acts upon me known as Michelle Christensen and upon the people of the United States of America. It will be an evil day for American liberty if the theory of a government outside our supreme law finds no judgment in our constitutional jurisprudence. No higher duty rests upon this court than to exert its full authority to prevent all violations of the principles of the Constitution. And then I cite a case law that would be Dawes versus Bidwell. That's Bidwell, and it would be 182 U.S. 244 1902, meaning the year. I petition, and then I go, I petitioner, I would say my name, Michelle, now moves this above cause forward as soon as possible and can be heard. In reference to violations, Title 12. Oh, you need to write that down. That's very important. So that would be Title 12, Chapter 2, Subchapter 4, 12 U.S. Code, Section 95A, and you want to put also 95B of Title 50, Chapter 37 of Title 18, Section 16112. I ask that you all write that down, look it up. You're going to be quite amazed because what I just cited you is what our government as Congress now and our state senators, they all know that. And that is why they don't want you to know certain things, because those are things that they follow. It's all written out in their book, their little black book. So if you look that information up, you will be surprised what you're going to learn, and you will also have information you can use to your advantage.
If I may?
Pardon?
If I may?
Sure.
Would you repeat that Title 12, Chapter 2?
I will. I definitely.
Go slower, Michelle, because you're going
fast?
extremely fast for somebody to write it down. So,
okay.
So do it in segments, okay?
Sure.
Okay.
Okay. It's Title 12, Chapter 2, Subchapter 4, 12 U.S. Code, Section 95A of Title 50, Chapter 37 of Title 18, Section 16112. I'll repeat it later. I'll also repeat it again. Yes, go ahead, sir.
Wow. How about as you go, I'll say okay. I say okay. Because I'm sure nobody. I got to subchapter 4.
Okay. I know. I'll help you out here. So you're going to put Title 12, and just put CH. That stands for chapter. So Title 12, CH, and then 2 for Chapter 2, and then SUB 4. That stands for Subchapter 4. That's what that stands for, SUB, and then 12 US, and then Code Section 95A.
Hold on. Section 958.
A, like the letter A, 95A.
Apple.
Like apple, and it's the small a, not the capital, small a. And that would be of Title 50.
But where did it change to a different title from Title 12?
Correct. There's two titles. That is correct. There's Title 12, and then there's Title 50, and then there's actually 3, and then you have Title 18. In that.
Now you said Title.
So it's Title 12, Chapter 2.
Yeah.
Subchapter 4.
Yeah.
Then 12, U.S. Code, or you can just say USC.
Yeah.
Section, which is SEC period.
Yeah.
95A.
Yeah.
Of Title 50.
Oh, of Title 50, no.
Yeah, of Title 50.
Okay.
And then it's Chapter CH period 37.
Oh, wow, no, no, wait a minute. That's not making any sense.
Yeah, it is. So it's like this. Title 12, Chapter 2.
Right.
Subchapter 4.
Right.
12 U.S. Code, Section 95A of Title 50. There's a lot there. Title 50. And then then after 50 comes Chapter 37 of Title 18. And then it's Section SEC period of 161.12. That's a mouthful, isn't it? Now, what I just revealed to you are many different codes and statutes there in titles. The reason why there's so many of them is because you're citing the land security, which is what they took an oath, okay? Meaning our Senate, da-da-da-da-da.
Okay.
They took an oath.
Can I?
Mm-hmm.
Title 18, Section what?
161.12. Now, for those that don't know what 12 means, we fall under Title 12. Title 50 is Homeland Security under Chapter 37. That's why Title 18. That's why it says of Title 18, Section 16112. That's where we come in. So that's why there's a lot there. So you're citing Title 18 under Section 12, but also under Title 12. That's why there's a lot there. There's a lot to look up. Now, I'm going to warn you, when you look up that information that I just gave you, that's where you're going to find out how you've been deceived by our governors and our state senators, etc., okay, including our presidents. You have to understand, or excuse me, I shouldn't use that word. I should have said you need to comprehend. Now, executive orders are illegal. Because back in 1933, and I'm going to go back into that with you in a few minutes, but now that's, in other words, we're not at war anymore. So when they address an executive order, what they are using is they're using emergency procedure, meaning that there's a war that has been brought forth upon the United States. They're using that claim as making it look like we're in war. Well, we're not in war. Now, that has to do with the executive orders. So that's where they're violating the Constitution and our rights and many other people's rights, including foreign countries, because we are not at war. That is illegal. They're not supposed to be addressing executive orders. And I'll get into that later. Now, you'll learn that now when you learn your Constitution and where you stand as we the people. Now, the people for the sovereign states, that's with a small s, not a capital S. You need to learn the difference. The people for the sovereign states for the republic. Now, did you hear that? Please write that down. We are not a democracy. When you hear somebody make that claim of democracy, you should put them right in their spot and say, excuse me, I want you to say the Pledge of Allegiance. Do you say I pledge allegiance to the republic, or do you say I pledge allegiance to a democracy? Now, you all know the pledge allegiance of the United States. It does not say I pledge allegiance to a democracy. It says I pledge allegiance to a republic of the United States. Now, I'm going to get into... Okay. In other words, what I'm trying to tell you is we've all been deceived. The democracy movement is illegal. It's treason upon the United States. Why? Because you need to know the difference what a republic means and a democracy means. A republic means by more than one ruler. A democracy means only by one ruler. And that is exactly what it means. And if you want to live under a privilege, well, that's what you're going to get under a democracy. Under a republic, you have more, in other words, you have legal rights as a whole pertaining to the law. Under a democracy, you do not. Why do you think all of these people from these foreign countries want to come into the United States? That's what they're fleeing from. They don't have, under law, a whole legal right. They only have a privilege under law. You don't want a privilege under law. You want your laws to be given to you as a whole, not under a privilege. Now, you're probably thinking, well, geez, okay. Well, guess what? President Obama, he actually declared martial law. Guess what he did it under? He did it under the executive order, which is illegal. Now, we have a senator by the name of Ron Paul who brought that out in a video, who actually cited our rights. He actually said it, where we stand as the people, because he was so upset. But see, we're so wrapped up at hearing, in other words, we're so wrapped up at being what we're told, we don't do our own research. Well, if you don't do your research, how do you know where you stand? How do you know how to protect yourself when it comes to your rights? You don't.
May I?
That's yeah, sure.
I don't mean to interrupt, but it's my understanding, and I was told this years ago, that's why they call it a war on drugs and a war on crime. It's fraudulent, but it's actually a declaration of war.
That's exactly right.
And that's
you're right. That's exactly right. And well, but it's a fraudulent war now, isn't it?
Yes.
See, you have to. We, the people, we have to stand up and tell these that are, in other words, we need to stand up and tell our senators and our governor enough.
Our public servants and employees.
Sure, absolutely.
Because that's what they are, folks.
That's right.
Go ahead, Michelle.
And who picked them? We did. We did. Now, here's something else that this is really going to blow your socks off your feet. Did you know that those that run for presidency are not supposed to be lawyers and attorneys? Did you know that? And if you do know that, ask yourself this. Why in the hell are you voting for somebody who's running for presidency who served in one of our branches of our government? They're not supposed to run in two different branches of our government. Did you know that?
Yes.
So, if you didn't know that, now you do. This is what they don't want you to know. This is why they don't want our children to know. This is why they don't want you to know about the Federalist Papers. Because remember, the Federalist Papers is also part of the Constitution. You know what else is part of the Constitution? The Articles of the Confederation, which was addressed in 1777. What they are doing is they are addressing as I put it, they are addressing the convention under secrecy. Now, any senator or governor or any of these news media people, because there's some that actually have sent me documents in the mail, and they want to alter our Constitution. In other words, they want to call for a convention. Anybody that wants to call for a convention needs their head examined. Do you want to know why they want to call for a convention? Because they want to remove the laws that are there to protect your rights that has to do with the Constitution. They want to alter it. When I get those kind of requests, man, I tell you, I put them right in their place and I send them a document like, really? Show me where you need to do that. And then I shut them right up real quick. Silence can be only acquitted with fraudulent
behavior.
Yes, thank you. It is also a legal or moral duty to speak, or where an injury left unanswered would be intentionally misleading. So when they hold information, which is what they're doing, and they're being silent about it, well, that's fraud. That's fraud. We, the people, need to start speaking up on this stuff. You need to start doing your homework.
Michelle?
Go ahead. What were you saying?
Ed and I always put that in our affidavits, the fact that if silence is acquiescence, if you don't answer this, you're admitting to fraud. So,
well, you can say it. You can say that, but you also can say or it's a moral duty to speak, or where is inquired left unanswered would be intentionally misleading.
Quote the whole thing.
Yeah, and that's good. That's why I recommend that when somebody's challenging the court, or when you're challenging an attorney or whoever, I always put in there, you have so many days to comply to this request, and if I don't hear from you within so many days, then you leave me no, in other words, you leave me no choice. I'm going to take legal action.
Actually, you don't really need to do that. In Canada, you have, I think it's 40 days. In the United States, you have 72 hours.
Right. Well, and that's true, and that falls back. See, now that also falls under violations regarding Rule 60. Because remember, if they don't act within a time frame, then they are in violations of Rule 60.
Right.
And you can go after them for that, and then there again, you would hold them in contempt of court. Now, here's something that I learned when I was looking up some information too, because we still live and learn, right? And it's about our elected, appointed public servants. Did you know that the chief clerk is elected by membership of the House of Representatives and serves a 2-year term? Now, the clerk of the court of the House is administrative officer elected by the membership to be responsible for ensuring that the chamber's business and proceedings run smoothly. The chief clerk or clerk's office is therefore responsible for multiple duties, including the proceedings of the official business of the House, providing the proper setting for consideration and indictment of the officers and other members on the proper interpretation of chamber rules and protocols. So you can use that to your advantage. Now, believe it or not, you can actually look that up. It's very easy to look it up in Google search bar. And then all government officials and agencies, including all state legislatures, are bound by the Constitution and must not create any de facto laws which counter the Constitution. again, that's where your conflict comes in. And that also goes against the doctrine of governmental immunities, which are unconstitutional, and others too enormous. To mention. We could go on and on and on. So it's just knowing your basic protocols and what you need to do and how to address these your documents, and you got it made. You don't have to be a rocket science to address yourself as you being a private sector, a non-commercial identity. And then you would say, whereas you as one of the people from in order to perform a perfect union, establishes justice, ensures domestic tranquility, provides for the common defense, promote the general welfare, and to secure the blessings of liberty to ourselves and to our posterity, and ordain and establish the Constitution for the United States of America.
Michelle, may I?
Yes, absolutely.
Thank you. I just wanted to clear something that I speak of. I don't use the word document because I'm not docking a ship. I use the word instrument because your instruments are supposed to sing. Go ahead.
Well, that is correct. But you can, as long as you're specifying your instrument when you put your document together. When you speak of a document, yeah, you're talking about a document, a piece of paper. But yes, if you're addressing an instrument pertaining to law, you should use the word instrument, and you apply it to your document. And yes, like Ed pointed out, you want to make sure you know the difference. And it is an instrument, by the way. It is not, when you say document, it's a piece of paper. Has no value,
no.
but
No.
What?
When you submit a document, are you aware there's certain rules you have to follow when you submit a document? Like you have to bind the document?
Correct.
So
well, yeah, I was going to clarify that, and that's where I was going. If you use the term document, a document has no, in other words, it has no meaning. It has no value. If you use an instrument as to addressing your instrument, as to what we're talking about, as to addressing the court or law, you would want to use it. You would want to make the claim as it being an instrument, because an instrument has value. A document does not. A document's just a piece of paper, has no value, means nothing. So and that's where. Is that where you were coming from, David?
What I wanted to clarify to people was that you were writing your instrument that you were writing, and you were attaching evidence to your instrument.
Oh, absolutely. Yeah, correct. And another thing.
May I?
Sure. Mm-hmm.
So, is that Ed that is speaking?
No, it
was David.
David? Well, okay. Ever since I heard that on another call, David, and ever since then, that's all. I never refer to a document ever again, no matter what.
And that's good.
Cool.
That's good. Just like the word I understand. We really need to get out of that habit of saying I understand. Instead, you should say, right. Instead, you should say do you comprehend? Because when you say I understand, you're putting yourself back into in other words, you're putting yourself back into the fiction side, which is the corporation. It's sad to say this, but unfortunately, that's how we've been deceived. And of course, what they did is they removed the title of nobility, which was the 13th Amendment, and what they did is they put us under. They put them above us and us under them, when it should be the other way around. We're supposed to be above them, and they're supposed to be underneath us. But unfortunately, they switched it.
Well, unfortunately, that switch is a fraud by trickery.
Oh, absolutely. That's right.
Against the Constitution. The first branch of government is the men and women of this nation, period.
That's correct. And
everything
that's why you need
self-evident, right?
There you go. That is correct. And that's why you need to know the meaning of the true bill. Because the true bill is the Bill of Rights. You need to know, what does the Bill of Rights mean? So now you know how important it is to know the Constitution. You also need to you also need to comprehend that the amendments to the Constitution are law. So when you read the Constitution, it's not just the Constitution, those are the laws pertaining to the Constitution, meaning those amendments.
If
so
I
when
may.
Yes.
I only consider the first 10 amendments lawful.
And why is that?
Because the rest were enacted after 1861, when the nation was, Congress was in a de facto status, and Congress can only legislate when they're in a de jure status.
Well, that's a good point, and that's why you need to know. That's why you need to know what's lawful and what's legal under that definition.
What's legal. You only want what's lawful, because legal is the British system.
That's right. Well, I said you need to know what's lawful and legal. He gave a good explanation as to the first 10 statements pertaining to the amendments of the Constitution.
And he's absolutely right. Only Congress stood sin by, never to meet again, since they didn't have enough votes to call the next session. So
right.
Without day, when they dismissed not having enough votes to conduct business, became sin by the next day when they didn't have enough votes to call the next session.
Well, and that's why it's...
I've not had a lawful seating of Congress since 1861.
They got good information.
I agree. I absolutely agree.
May I interrupt
and that's
one more
sure.
time? Is Dave in Ohio?
Yes.
Okay, okay, Dave, good. This is Santa Claus in Cincinnati.
I recognize your voice.
Hey, Santa Claus.
Hey, all right. I'm muting.
Now, that's why it's good to know where you stand.
Can I add something about that?
Yeah, sure.
Santa Claus, are you ready for Christmas to go deliver all the presents? Sorry, I couldn't resist. You know me.
Yeah.
Now, you want to know what's really good is when you use Marbury versus Madison. Now, write this down. And that's Marbury versus Madison, Madison, 5 US 137, and that's dated as 1803. Now, I recommend that you guys look that up and read it. Now, you have to comprehend. The reason why I'm asking you that is because that case law has been cited many, 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 many times. And you want to know what? Every time someone challenges that case, they end up losing. And the reason why that is because Marr versus Madison sticks up for your rights as to the Constitution. Okay? So that is a case, and you can actually pull it up, and you can see how many cases have come forth in court under that, and the judges can't go against it. There's no way the judge is going to go against it, because if they did, they'd be committing treason upon the court, because it would be a conflict. And remember, what did I say about a conflict? A conflict is null and void under law. You can't proceed.
If I may.
Mm-hmm.
I found one more nugget the other day, and it's about beneficiaries. To be a beneficiary to the Constitution, you have to know that you are an intended third-party beneficiary as one of the people. But a public servant, once they swear an oath of office, is an incidental beneficiary without rights. So if you look those up in the words and phrases books at the local county law libraries, your cases will change very quickly, and something to use against you. It's something to use in your cases.
That's right. That's why when you cite your cases, you should use the U.S. Constitution, Article 6, Clause 2, which is the supremacy clause of the United States Constitution.
Michelle, I'd like to add one more thing for folks.
Mm-hmm.
When you're putting your affidavit in and you've been kidnapped and held for ransom and they didn't read your Miranda rights, make sure that's in your affidavit that they didn't present your Miranda rights.
Good. Yeah, that's a good point.
Because once it's in writing, you cannot dispute that after the fact.
Here's something else that's really interesting too. If you actually Google in your search bar the 1838 Article 4 of the United States Constitution, you actually can look up in the original Constitution. Now, if you read it, holy cows, you're not going to believe this, but they actually tell you how to address the court. And they talk about the Supreme Court and and they'll give you a case law, because case law, like I said, is awesome. You want to cite case laws that are in your favor, that, in other words, regarding immunities and privileges, because that's a case that they actually cite in the Constitution, which is 1838 of Article 4 of the United States Constitution. They talk about the territories regarding the convention. So the Convention of 1838 of Article 4 of the United States Constitution actually gives you the legal information you need when it comes to challenging these people, or well, I wouldn't call them people, but I'm going to be nice on the phone. All right, now I'm going to go back.
Michelle, could I add something real quick for people to be aware of?
Yeah.
San Francisco judges, Chief Judge John Stewart and his colleagues dismissed 66,000 arrest warrants against the homeless and the indigents in the city of San Francisco. And I yield.
If I may?
Yeah, go ahead.
Go ahead.
Can you email that to me, Ed? Because I can use that here. The chief of police is now running for sheriff, and his department was persecuting the homeless here and running them out of the city limits.
Oh, yeah, I think I already posted it on your wall, but let me go double check and see if they'll allow me to post it, because I'm having difficulties with Facebook right now trying to log me off, because I guess some tyranny has been placed on my Facebook by some of the people, so some of the terrorists, I should say, because they don't like that we have lawful rights and we're not playing legal to our status.
Yeah.
So I will have that to you here shortly, and I think I posted it on your wall, but I'm going to try to attempt to do it right now, and we'll go from there.
Okay.
But yeah, no, that's a good evidence piece you do. And the one thing I want to bring up while Mike is here, please look at Citizen Action Network and look at with Mike, because I've got things where people are commenting, dealing with smart meters, and I'm finishing up an affidavit on that, so for myself and others can use it. But Mike has already got some filings done, and I encourage you to look at the filings, what Mike has been doing too, and realizing that some of the stuff Mike has done, he's watched others fall on their face, as we know how that goes. And so he's like me. We sit there and we watch and we learn, but we're not willing to put our neck out until we know the circumstances of truth.
Well, I do. I get in people's cases and help them out, and their cases turn. And I've had people, incarcerated people, that have called me. I've been able to help them, give them information they could write down and use it at their next court appearance. That's funny as hell, because the judge never expects them to put proof of jurisdiction on the record.
I know, that's the point, and that is the point people don't comprehend, and that's where I always bitch at people. Know your lawful and legal standings, because there is a difference of that, and trust me, the federal agencies truly do know that. Believe me, I know, and I dealt with them on many cases myself on it. They do know this, but it's the way you present your attitude to the circumstances.
Oh, absolutely. You are so correct, because if you go into the courtroom with an attitude and you go in the courtroom and you're complaining and whining, if you think they're going to sit there and listen to that, absolutely not. But if you go in there and you can cite these case laws, boom, 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 I mean, that judge is gonna look at you like, ooh, this guy's done his homework.
Not only that, you claim your status if you're lawful or legal. So because there are cases for legal citizens that apply, and there's cases that are above for lawful Americans that supersede the statutes of citizens.
Right.
Go ahead.
That's exactly right. And when you cite, that's why it's good to know your Constitution and know the case laws that are sticking up for the Constitution and your rights. Because remember, you're going in there and you're proving with intent. If you can show that they're acting with intent, well, that judge is going to perk up real quick. Because remember, when you can prove intent, that's how you win. It's all about showing with intent that they committed an act intentionally or with intent, or they withheld information with intent to deceive. When you use that, yeah, sure.
If I may.
Mhm.
Yeah, it's a little different when you're being charged with something or when they have your property.
Yeah, I'm going to tell you.
When they kidnap your grandchildren and you challenge the jurisdiction of the court and they ignore the challenge of jurisdiction, when they commit conspiracy to interfere with justice by ex parte letter and hiding it and refuse to accept felony charges for those activities, when there's 28 affidavits brought under evidence rule 301, and they separate all the affidavits out and say that the case is frivolous without the evidence, and remove the evidence from the case.
If I may.
And
did you have your affidavits notarized with a Jurat form?
Yes, I did.
And how did you send them to court?
I sent them to the court certified mail.
Did you file anything about mail fraud or with the IRS?
No, I didn't file it with the IRS. Mail fraud is a strong point, but the federal court's the one that separated the evidence from the case and said the case was frivolous without the evidence. The West Virginia Supreme Court concealed the writ of mandamus for 19 days. I have two different filing dates on the same document. I have one of September 3rd, one of September 22nd on the same document. The West Virginia Supreme Court came out and said the Constitution was not law.
Oh, God. That's amazing.
Okay. You got to write were you listed as a defendant?
I was trying to recover a child that had been stolen.
That's not what he asked you.
Were you listed as a
what?
defendant? Were you the defendant?
No, they listed the child as a defendant.
So are you a parent?
A grandparent.
It's if you look at City of Moore versus East Cleveland, Ohio, that's the case you probably want to use.
Okay, well, I want to have fun getting it back in court again because it's already been as far as the 4th District Court, and they separated the evidence from the case and threw it out.
Yeah, but that's tampering with evidence. You can file on that.
Well,
it's judicial misconduct. If they place the child away from the best interest of it, like your grandparent, you're the most loving person in its life, obviously, or you wouldn't be going after it. So that's the case to use. You can bring it back to the court for a writ of error. They have to review it.
Well,
you can also file he can also file a motion for removal and get it out of that court system or whatever court he's in.
You can bring a new complaint. If you look at Rich Summers' pro se complaint, it's a pro se complaint for ineffective assistance of counsel by bar attorneys, and we've disqualified all the attorneys from participating. Even the magistrates and the first two assigned to the case have recused themselves for the conflict of interest.
And I got a question. Why are you addressing the court when you should be doing it under a grand jury? So why are you not?
Because there are no grand juries in West Virginia. There are no grand juries. The grand juries there are appointed by the court.
Right. So they're appointed by the court. So that means you would have a grand jury, but they're going to pick the peers. right? Is that what you're saying?
Yeah, they're going to pick your peers. Yeah, they're going to pick their peers.
If I may.
Go pick the. Yeah, go ahead.
Do you have 25 people that would support your claim, the right to the child?
I'll see if I can muster them up.
If you can get 25 to 30 people together that all sign off that, yeah, you have the best interests of the child at heart, and get that all notarized, you've adjudicated the matter in front of a common law grand jury of the people, so they have to honor it or address it in the court.
And I would even
strange in West Virginia.
And I would also move forward and file a separate claim against the judge for violating your due process rights and for violating the Constitution, even though, quote, they said that to you, and that's what that's fraud.
Brought upon the court.
Sure it is. It's brought upon the court, and of course it's violations. It's in violations of the. That's why you have to use the Constitution, and you have to cite case laws to back you up, like the gentleman that was just talking a minute ago, and he brought that one case, and he was telling you what to use. If I'm telling you right now, if you were to petition the court and you had your documents or your instrument in line, and you were citing these case laws pertaining to the violations of the Constitution that they are committing, including your state, I'm telling you right now, that judge is not going to go against you if you hold that judge accountable. But you have to come out and say it. You have to challenge that judge. Don't act afraid of that judge.
I'm telling you right now, they already did. And when I challenged the jurisdiction of the Supreme Court and brought it out that they had committed this prison of felony, their response was to throw it in the trash can.
Well, then what you need to do is you need to, and then you need to file a motion to vacate. You need to file a motion to vacate, and then you just keep putting it in there.
Yeah.
Learn how to
The federal courts chose to cover it up because it's an embarrassment to the judicial system.
There you go, bingo. That's exactly right. So you have to request for a new judge. In other words, you're going to have to challenge it, and you probably could even move forward. I'm trying to think on that. Let's see. Oh boy, because you got so many violations pertaining to the Constitution.
Until they answer jurisdiction.
What was that, Dave? What was that, David?
Case cannot move forward until they answer jurisdiction.
Well, he can also and that might be that would be in his favor, because let's think about that. If they don't answer, then they would
threw the case out of court, or any other judge threw it out of court without establishing jurisdiction. He committed fraud upon a court.
Sure, he did.
Perjury.
If I may.
Absolutely. He could hold him. You know what you can also do is go after them for identity theft.
Right.
That's how I won my case. I challenged the judge. I actually told the judge, I didn't consent to the taking. Wait a minute, you're addressing me in all caps. I'm putting you on notice that I'm filing for identity theft regarding you using my identity, and I didn't consent to the taking.
Okay. Well, we've talked about this case before, I think. You're the lady in Florida?
Yeah.
Okay, yeah, we've talked about this case before.
Yeah, well, and I'll tell you what, you'll win. Now, that goes back to the instrument. That's how powerful, when you use the certain words and you bring in case laws. Because remember, the instrument has value. Now, let's talk about the instrument, because the instrument also pertains to us addressing our paperwork, right, as an instrument. Let's talk about the currency, regarding commerce and the treasury of the state. Remember, it falls right back on them, because the instrument is the only thing that has value. Well, let's think about that. So there's different things. You're just going to have to do your research. You're going to have to look up these case laws and cite them. Now, one of the gentlemen that cited them very well, and that was I can't think of his name, something Miller, who who addresses videos as to knowing your Constitution, he actually cites a video. He's got where it's a set of 3. And he's teaching you about certain case laws and how to address the court using the Constitution and the amendments to the Constitution. He does very well, and he rattles off real quickly, but he's doing that on purpose because he wants you to understand when you do that, that judge is going to, in other words, that judge is going to sit straight in its chair and he's going to be listening to you because you're not going in there, and he's going to be, in other words, it's part of its acting. I hate to say that, but it's true.
What I've found to be true there is nobody really cares because West Virginia is under one court. The West Virginia Supreme Court of Appeals is a directive over all the other courts.
You can file a declaratory judgment.
The fourth district court does nothing but defends the West Virginia Supreme Court.
Well, no one's bound to obey a non-constitutional law. So you can address a declaratory judgment.
Michelle,
Yeah, go ahead.
Okay, just the gentleman in West Virginia. I understand completely or overstand completely what he's saying. I live in Chicago, Illinois, and I sued the company I work for taking my property and turning over 85% to the Internal Revenue Service based on a fraudulent notice of levy. I also sued the Internal Revenue Service. That case is pending. Well, I should say not pending, but the judge dismissed it and told me I could come back by January 20th and file an amended complaint. And in that second case, it went to the U.S. Court of Appeals. The Court of Appeals has told me that they affirmed the lower court's decision, and they have threatened to sanction me if I move forward with further litigation. Now, mind you, based on my research and my understanding of the Internal Revenue Code, I completely destroyed everything that they've done. But just as the gentleman in West Virginia is stating, what do you do when you cannot get the judge to honor and uphold the Constitution?
You have to file a judgment again. In other words, you have to hold that judge accountable, and you would have to file a separate claim, a separate lawsuit, and you would have to go after the. You'd have to go after that judge.
Okay. With that being said, is there anyone on the call that could assist me with that? Because again, I've made it to.
The gentleman who is speaking right now. Have you been informed of the case in Tennessee, U.S. versus Lloyd R. Long?
Yeah, yes, sir. I know the case very well, but the problem here in Chicago, Illinois, these are original gangsters, and these judges and the appellate court judges do whatever they want to do when they want to do it. That's the problem we're having here in Chicago. They don't care about.
This is a constitutional issue. All the tax laws are void on face ab initio because the 16th was never ratified. These judges are committing treason.
I understand that. And if someone could, I just need some assistance on how to move forward with my criminal complaint because, like I stated earlier, they don't care what you're saying when you come into these courtrooms. They don't care. They just try to do what they do.
Well, let me ask you something. Did you file a notice to vacate against that judge?
No, I have not done that yet. But what I did do is file a motion to, I asked the judge to recuse himself. He denied that motion. I also filed a motion for substitution of judge. That presiding judge also ruled on that motion to substitute, which he should not have done. That should
Correct,
have been
I agree.
But he did it. And again, what I'm saying here in Illinois, and they threatened me with sanctions if I move forward with further litigation.
There's a lady, yeah, go ahead.
I'm so sorry, guys. Michelle, my name is Angie. I'm actually located in Colorado, and I don't have a lot to offer the gentleman who's asking this other than I have to address what you just stated about bringing forward a separate claim against that judge. I, in fact, did that last April. I had the judge in North Dakota where I was living at the time, due to this judge just slaughtering me left, right, and sideways. I brought a claim of trespass against him. I had him properly served by the county sheriff On April 6th of this year, April 12th, that judge filed an order stating I may not file at any district court anywhere in the state because of that coming against him. And I'm stuck because they won't let me file. I have, in North Dakota, you first serve the other party when you receive back your the proof of service from the sheriff or the process server. In my case, I hired the sheriff. When I received that back, I was then to go to the courthouse and get a case number and file that. Did
you file a notice of removal? In other words, okay, I would try a notice of removal and get it into a different court district, and you would claim that they are acting biased against you, and also I would claim that's a threat.
Yes, ma'am. I didn't do a notice of removal. I actually had asked for him to be recused prior. He took my baby girl away from me with no hearing at all. It's been 15 months.
Oh, geez, so they violated your due process rights.
My 5-year-old daughter was arrested and taken and held custody because the father wanted her that weekend. It was my weekend. I desperately need help. I am dealing with this guy up there. I did file for a recusal. He won't recuse. I also sent him, I had this published in the paper, and I don't mean to take over the other gentleman's position. I had it published in the paper for 3 weeks, public notice that I filed a claim against him. If he didn't respond, I would win by default. I've sent all this into the Judicial Conduct Commission. I sent it into the presiding judge. I sent in all of my documentation. I sent it to, yes.
Are you still responding to the original complaint, or did you bring a new case?
I had brought my own claim against this judge, my very own claim, and he told the clerk I could not file. I took it to my county where actually I was living at that time, and I tried to file it there. That judge said he could not take it, and how dare you, you're in contempt of court, he told me, because there's a standing order that says you can't file in any district court without the other judge's approval.
If I
may?
Yeah, go ahead.
There's denial of due process of law. But if the lady wants to talk to me sometime, I've been fighting this stuff for 3 years. And my phone number is 304-992-1592.
1592?
1592, 1592. 304-992-1592.
Your name, please?
Daniel.
Daniel. Hi, Daniel. My name is Angie. Yes, I will definitely sure appreciate. I have been fighting this for the last couple of years, and now my daughter is in extreme danger, and I'm just blocked.
Yeah,
I know the feeling.
There's something I want to bring something to your attention that you just mentioned. In some way, or in some ways, that judge was correct, because here's what happened. Now I'm just assuming. And I could be wrong and I could be right. You can't, in other words, when you address the court in one jurisdiction, so you go to court and you're addressing that jurisdiction pertaining to your case, you can't take that case into another district until you close out the case that you had opened pertaining to the other jurisdiction. Do you follow me what I'm trying to say? So if you didn't do that, you would be violating that judge's right, and that's what that judge was referring to by he can't take the case because you have to close the other case with the pending judge.
Well, what the order stated was that I better just go jump off a cliff because, and he threatened me with contempt and sanctions because he said that the other judge, who I filed against, got to decide that I could not bring a claim against him, and said no, I could not do that, that I was taking an incorrect collateral attack.
Right.
I brought a claim against him for everything he'd done wrong, and that he won't let me into court. Period. And he says,
then that's
no,
where you, if that is where you're at with that court, that district, then you need to file a motion to vacate. You need to file a motion for removal.
And to remove him or to remove it from that area?
Both.
It's both. In other words, you're moving it into a new district.
If I may.
Yes, ma'am.
Yep,
I did
go
try
ahead,
that.
sir.
I was denied.
Angie, I'm emailing Ed and a couple other people 2 PDFs I found today on Section 1983 litigation and what the Supreme or what the Ninth Circuit Court has held and dismissed and overturned, and it's pretty powerful stuff, especially the glossary. So if you know how to get a hold of Ed, he can pass it around, or I can again. But between those 2 PDFs, if you just look through the glossaries, key sections will stick out, and then if you research those, it'll unlock your cases.
You know, another one too you might want to look up, since you're going in that direction, is United States versus Twill. That's TWEEL. Regarding 1977, that's the year. I'll give you the number. It's 76-2324.550 F like in Frank, and then 2, the number 2 with the small lowercase d next to it, 297, and then 1977.
Okay.
You might want to look up that, because that has to do with trickery.
Okay.
That case that I just cited to you, it has to do with trickery upon the court. Keep in mind, when these judges threaten you like they're doing, that means that whatever you did, they're afraid of you. So when they threaten you like that, that tells me that whatever you did, because I don't know, I haven't seen your documents, so I don't know what you did, but that means that they became afraid of you.
Mm-hmm.
And that's why they threaten you, and that's why they block you, and that's why they don't want your case to go forward. Because remember, when your case goes forward, what does that do? It makes a public record.
Dang right. I put it in the newspaper.
Yeah, I think I just emailed you my email address. I just sent it to you, Messenger. So you can email me, and I'll make sure you get that information. And the other gentleman at 304, re-email me, and I can pass the other stuff on, and we'll pass information back.
Okay.
Good luck. Sure, go ahead.
Angie, if
I may.
Wait a minute, one at a time, please. The first may.
The way these people function in these child abuse cases or child custody cases is under a sealed record, and they maintain that sealed record, and that's how they get away with everything they get away with, is by maintaining a sealed record.
Right, but see, you could get a sealed record unchanged, and this is the point that I'm trying to get, because I'm getting ready to file my case in the Supreme Court law of Washington, D.C., and Philadelphia is the only lawful court in this country.
Yeah.
So it is going through those channels to do it, because the point I've been dealing with Oregon, and not only spending time up at the Capitol and watch how these idiots do stuff, and I don't know why my thing keeps popping up. But anyhow, the whole point is doing this so you're creating the record, and so when it goes into the Court of Appeals or goes into Supreme Court, this is the one thing I'm trying to get to people's comprehension, that, we keep arguing with these lower courts, and this is why they keep getting away with it. So we need to take it to the Supreme Court and put it in this. And also, too, I don't like the word motion. I put a demand in on public safety as well as bloodline safety. Because remember, these judges do know what bloodline really means. Lawful Americans, they do know what it means. I've had many conversations with the State Attorney General of Oregon, House and Senate members, what they call legislative council. I've been through this stuff, and they don't want people to know the process of how to go above their head. Because they're terrified, because if you know how to actually go above their head, I mean, I got people that I've walked them through different things. They won their case, and then when they won their case, they just walked away from everybody. Mm-hmm. And this guy keeps going that there's no lawful Americans here for 100 years, and Brian, you're so full of BS because the natives have been here for hundreds of years, and I don't care about your immigration issue because immigrants have no rights in this country, and that's the one thing we've proven to Congress. This is why Congress has just revamped an immigration law to send them home. And you better pay attention to what's going on in Congress, because I sure am, because I'm dealing with these men and women proving our bloodline. And that's the one thing that the natives need to stand up on their bloodline and burn the damn Bible and start being Americans again, taking back the heritage of the Great Spirit and Mother Earth, because without Mother, there is no life. And so it disturbs, wait a minute. It disturbs me that these people from other countries want to come in here and rape, rob, and pillage our children, our bloodline, and our family for their own personal needs. They don't have rights. And that's why I'm waiting, and I'll be the first one to ship people out of this country. And I've made it known to Congress, the House and Senate in my own state. I've said this on the House and Senate committee hearings for the last 2 decades. And so lawful Americans and lawful bloodline Americans is filed and copyrighted in the House and Senate and in the newspapers with my name to it. So I just want to clarify that immigration is that we have to start filing our grievances with your House and Senate to send these people out of the country, and then they're going to whine, what about my children? Well, your children should blame you for having children in our country because you're the responsible party. I yield.
If I may,
wait a minute. Let the other guy finish his conversation that I interrupted, and we'll pass it to Mike and then back to Michelle.
In West Virginia, under 5174, the West Virginia Code, or 5171, pardon me, the court reporter works directly for the judge. She's there to serve the needs of the judge. There is no verbatim record of what goes on in the courts. And further, the Supreme Court regulates which portions of the record you are allowed to have to address. And so there is no accurate record of what goes on in the courts in West Virginia.
If that's the case, that is a violation right there, and that's where you or whoever is facing that problem, you have to do your homework then, and you need to hold them accountable, and you need to look up case laws that will back up your claim, and of course use the Constitution. Because remember, a lot of us that have addressed the court,
they don't recognize it.
I know they don't recognize it,
right?
Sir,
but see, you listen to her how to do this, because you got to bury them with the structure. You bury more than one of them. This is what I have done: is I bury the House and Senate, I bury the State Attorney General's office, I bury the Ethics Committee, I bury the Public Standards Commission, I bury their oath of office, because there's an oath of office that they have to take. There's an oath of office in every state that they have to go by. And you file on all these things. And I'm getting ready to put out a 30-package email, getting ready for my case to go out, because my case is going to be interesting, because I can prove so much stuff in the fraud with the House and Senate and other stuff that's going on, because I can prove it. Not only did I live it and witnessed it, but I have it in my instruments, because it's already been in public record that they denied. Because they wouldn't prove forward, but it's all listed in all the records of the House and Senate. You make sure that you have the recorded record. And hang on a minute, Michelle, let him finish, and then it goes to Mike, and then it goes back to you.
I am.
There is no recorded record there. There's only that woman taking on that ticker tape, and she there works for the judge. And
okay, here's what you do then, sir.
10,800 seconds of court process.
Right.
At 3 hours. She recorded 4,404 words, less than 1 word every 2.45 seconds.
That's tampering with the court record, and that has to be filed on. That's why I suggest to everybody, when you go to court, you always take a recorder with you, a video camera. They sit there and tell you, oh, you can't do that. Well, then you have to ask them to clarify in writing, is this a court of record or is this a closed-door private corporation? You have to put that in writing for record. You send it registered, certified to the state attorney board. You remember, all these places have a board of directors. Okay, so you go after the board of directors of their financial means. Okay, that's the whole point. You got to go out. Hang on a minute, Michelle. Let him finish, and then Mike will go. But the main thing is that you have to file this with the board of records, because I tell everybody, it's like what gets to me what goes on with the Dakota tribe right now. All right, nobody filed criminal complaints. Now they're filing a lawsuit that could be dismissed. They're not filing criminal records on the board members of the oil company, which I have suggested. I've even talked to people over in the tribe, brought this to the attention, and how they can do it in their own court system of the tribal court that supersedes the corporation court. But all these guys keep telling me, oh, they want to talk about the Bible, and they want to talk about this. And I'm like, do you really care about what you're saying, or are you just pulling bullshit so you get a government check for your tribe under the American Bureau of Indian Affairs? And then they don't want to talk anymore. And it's really frustrating, because this is what they're doing, is selling out their bloodline for a piece of paper or a position of titlement. Now, go ahead and finish it, then Mike, and then the floor is yours, Michelle.
I'm sorry, Michelle, if I may.
Yeah, go ahead.
Yeah, I was the guy in Chicago who kind of started and didn't get to finish. So I just got a statement. I'm hearing everybody making these comments, and I have a case in appeals court. I'm probably gonna have to fill it to the Supreme Court, and I have another case against the IRS where the judge has dismissed the case. He hasn't reviewed, and he told me in open court he wasn't going to look at any of the documents, any of my FOIA requests or anything. So my question to anybody on the call, is there anyone that will accept donation, payment, whatever you want to call it, to assist me in my situation? Because I keep hearing about what we should do, what we should do, what we should
right.
do.
Yeah, I'm going to help you.
You have my email, don't you?
No, I don't.
Let me give it to you. I'll give it on the air. But make sure you send it to me 3 times. I will pass the information amongst us, and we'll see what we could come up with. All right? My email is all lowercase, because I preferably try never to use capitalizations in my word or anything like that. Because I do remember when I went to school with my English teacher, actually taught us about capitalization. She was very honest in school. It's Ed Johnston, all lowercase, 2003, at yahoo.com.
Okay.
And I believe I personally talked to you on the phone, haven't I?
No, you haven't yet.
Oh, okay. I'm sorry. But you have my email. We'll get it amongst us. We'll see what we could, bury you with some information, and we'll go from there. Because I know Mike's got a lot of good information. That's why I tell people to go to his Citizen Action Network and his site and start looking it up. Go ahead.
Okay, let me read it back to you.
His case, so we know what to do, to look for, to help him out.
Let me
say that again, David.
I say we need a copy of your case so we know to look at your instrument. To find out how you actually filed it, and if there's anything we can do to change your paperwork to make it more, let's say, stick.
Okay, let me read the email back, and I'll upload my 2 original complaints, and then whatever else you guys need, I have copies of everything. I'm very, very thorough with detail on everything. So let me read this back. EDJOHNSTON 2003.
STON, yes.
STON 2003 at Yahoo.
Yes.
Okay, and I yield. Thank you very much.
Yeah, because that's very important.
Michelle, would you be okay with giving me your email address as well?
Yeah, sure. It's Fawn Meadows.
Can you spell that for me?
FAWN MEAD
MEAD
OWS MC at AOL.com. Yeah.
At AOL. Thank you very much, and I yield.
Okay. Yeah, because that's the problem. we listen to people, and my heart goes out to those that have challenged the courts, and of course I give you credit for that. But sometimes, it can take one word in your document. In other words, change one word in your document, and it can mean a whole lot. Because sometimes what happens is we focus on the big things, that we sometimes forget to focus on the little things, and sometimes we forget to even make a request. And Ed pointed out a good thing. When you address the court or you're addressing your instrument, you demand. Now, you file a motion, like for instance, when I use the word motion, I'm filing a motion for, in other words, I'll say a motion for default. But then but after I file my motion of default, I claim it as what I'm claiming, and that's regarding my instrument as to. Okay, thank you. As a demand. So I demand, when it comes to what I'm addressing to my instrument, what I'm asking for. So I demand you to do, I demand this, and this is what I want, that type of thing. So when I use the word motion, it's motion for default, but I'm using it against them. Not for me, not for my purpose, but against them. Because remember, when you address the court, you also don't want to look like an idiot either. Because, we have a bad reputation going on with us people, because a lot of us that have addressed the court thinking what they were being advised as doing made them look like idiots. Now, I hate to say that, but that's the truth. Some of us were told the wrong information, and we believed what we were told, and we did what they told us to do. And then, now when other cases go into court, like us, for instance, they look at us like, oh boy, here comes another one. I mean, we're labeled. I hate to say that, but that's the truth. Just like how it's all about mind control. Remember, it's all about making you believe what they want you to believe. Well, don't fall for their trap. Keep fighting them. Keep fighting them. Try to figure another way of going around it. And the gentleman, like we're going to help, we have to look at your actual case, just like if we were an attorney. We have to look at your entire case. We have to see what you've done. We have to see what they have done in order to help you. And that takes time. That's not just something, in other words, you can address a document and it can be outstanding. But if you don't know what the hell you're doing when it comes to your document, and you don't know your case laws, and you're not citing them like boom, 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 boom in court, well, that judge is going to say, oh, brother. In other words, the judge is not going to be in your favor. The judge is going to be in their favor. So you have to really be persistent. In other words, go in there. This. That's why I said to listen to the video. It's on my wall on Facebook under my name, which is Michelle Christensen. I actually posted a video that, who, by the way, the gentleman has challenged the court many times. He's also challenged the court on driving without having a license or a tag on his car, and he's won. He's actually won many cases, and he has helped other people with their cases. I recommend you go listen to his video on YouTube, and you'll listen to how he talks.
Tell the name of the guy, Michelle, because not everybody has video, not everybody has Facebook.
It's Know Your Constitution. His name is Miller. Sorry, I can't think of his.
Carl Miller.
There, thank you. That's it. And his title is Know Your Constitution. So if you even Google search Know Your Constitution, he'll come up.
If I may.
Yep, go ahead.
Well, part of the problem, too, is that people aren't trained to do research. And a good resource is your county law library, because they have a lot of good reference books, and you have to go through it and look. But you'll find stuff that'll help you, because you want to find the federal section, basically, on how to enforce your rights. And they have the words and phrases volumes in there, and you can look up words, because that adds a lot of power to your contracts, because it shows you pro and con for a lot of.
There's a good point. That is a good point. I highly recommend that. And by the way, if you look up the Barefoot's World Net, there's a 6-page article that he has put together that will help you, and he actually cites in that 6-page document what is actually going on and what we are facing today when it comes to our senators, Congress, and the government as to abolishing
elected and public servants.
May I?
If I may.
May I?
Go ahead, then Dave is next.
In West Virginia, there are only 3 county law libraries in the entire state.
Well, you can also go to you on the internet. You can actually go to the main court's website, which is the, believe it or not, is the brain fart. Sorry. Help me out, David. We were just talking about that.
The Supreme Court.
No. What we were talking about as to where.
Talking about the West Virginia Supreme Court
Columbus.
Library.
No, about the website on the court.
You can go to the law library and reference cases if you know the case, but you can't cross-reference cases in the West Virginia Supreme Court Law Library. You have to know the case when you go there.
A lot of colleges have law libraries too, so you might want to check with your local college.
Oh, now I know what I was trying to say. District of Columbia. If you go, believe it or not, if you go to the District of Columbia, now this is on the internet. If you go to the District of Columbia, the main court's website of District of Columbia, they actually have documents drafted up for us, for we the people. And what you do is you fill in the blanks. But you have to go to District of Columbia, their main court's website.
So that won't put you in touch with legal research, though.
Yes, it does. It actually does.
Well,
and
Supreme Court cases only, but the West Virginia won't recognize it unless it's their own. If it isn't their ruling, they won't recognize it.
What you have to do, well, I know where you're coming from. What you have to do is you have to cut and paste off of their documents, and you have to modify them for the district that you're addressing regarding your state and your county and da-da-da-da-da.
Do Chicago and West Virginia both, do your states have a styles manual at the state government level?
Say again, sir?
Do you have a styles manual, a state styles manual?
If there is, they won't let you have access to it. There's no law library available to you there. Southeastern West Virginia, there are no law libraries. The nearest one's 100 miles away.
Yeah, but this is not a law library. This is with your state government.
But you can't access all that. It's not available to the public. It's private law.
No, it's not. Well, no law can be private. The Supreme Court's already ruled that.
Well, they won't let you have access to it unless you go to the Supreme Court building in Kanawha County in Charleston. You can't gain access to any of that. It's not available to the public unless you get on the toll road and drive to Charleston.
Well, let me ask you something. Are you telling me that you can't even get that information up through the internet?
You can get internet information, but if you don't know the case before you look it up, you can't look it up. You can't cross-reference.
It has no case.
Okay, well, I didn't get into the styles manual, but I could cross-reference. That was one of my bitches with them, is that they wouldn't allow me to have access to a law library, and it didn't seem to matter to them. I had limited access to the internet, and that's it. In fact, where we live in the country there, unless we paid an exorbitant amount, we wouldn't have access to the internet either. So I was using the public library's internet site to gain access to the internet, and that had limited hours and limited access, and you're on the state internet there, and there's certain things that you aren't even allowed to access there because the state owns the state library's internet.
Well, I can tell you this: there's other ways of getting case laws, because I have found many, many good case laws, and
I did too. I did too, but they ignored it.
Well, I don't know. The problem is, I don't know how you're drafting up. In other words, if you're just citing case laws and you're not, I don't know how you're doing your paperwork up. So if you just
Michelle, I'm in Texas right now. I'm on Texas.
Mm-hmm.
But as soon as I get back up to where I have internet, I'll email you a bunch of stuff. And, let me ask you something. Now, are you the one that was trying to get or was addressing your grandchild? Yes.
Okay. Yeah. See, what we have to do is we're going to have to look between David and I and Ed. We're going to have to look at what you've done. That's the only way we're going to be able to help you, because.
What the real problem is, Michelle,
there's more to it than just addressing case laws.
What the real problem is under Title 4D and 4E of the Social Security Act, if they can convert a child into a special needs child, the state stands to profit $1 million or more.
Yeah.
Yeah.
So
of course, that's where you have to challenge them, and you have to force them to show cause. See, I don't know how you're doing your documents. You have to force them to show you why. You have to know how to say. Well, in other words, you have to force them to show cause.
If I may.
Mm-hmm.
It's you want to use your tools of discovery. It's requests for admissions, requests for production of documents and records, and interrogatories.
And they all say that it's all sealed record. In West Virginia, we requested 22 transcripts, court transcripts. We were allowed 2, but neither one of them were accurate.
Wow. Well, you know what? Now, if that's the case, I mean, I don't know how you're doing but if you did that, and if, let's say, for argument's sake,
if you go to the FBI website, you can file a complaint right now for judicial misconduct. I would start with
You're
that.
Not a kidding.
Yeah.
Judicial misconduct with who?
The FBI.
The Federal Bureau of Investigations.
Well, that's where it needs to go then.
And if you do it over the internet, certified mail a copy in, print it out, certified mail it to them, and then certified mail another copy to yourself and sign it, but don't open it. Make sure you sign it, date it, put your right thumbprint and red ink on it, and then
good point.
Wait for a response.
Yeah, that's a good point. You definitely need to be following those claims. A judicial misconduct and attorney misconduct, the whole 9 yards.
The one hearing lasted in excess of 3 hours, 10,800 seconds. This was brought before the Supreme Court. It lasted in excess of 3 hours, 10,800 seconds, and the court reporter published 4,404 words, less than one word every 2.45 seconds.
If I may.
Yes.
If you go to citizensactionnetworks.com, on the Attorney Information tab, there's a document if you click that, it'll have a drop-down menu, and on the middle bar, there's a COLE form or a violation of rights warning notice. You want to print that out and then fill in that form and send certified mail that, have it notarized with a jurat, and then certified mail that to the FBI with your letter of complaint, and quote, circle Title 18 U.S.C. 245 on there, because that's your federally protected activities as a third-party beneficiary to the Constitution, which are life, liberty, and pursuit of happiness.
Good. And I would add, since you're going to, when you do that, is get copies of your friends or who's ever that knows you and have them draft up an affidavit claiming that you're a good grandparent, and whatever they know about between you and the child and the child's parents or whatever. In other words, have them do an affidavit of truth, and add that as your evidence. You could even put that in there.
In the citizen statement area, just put Judge so-and-so is a member of the bar and find their bar number and attach it in there, because then as soon as if the FBI does or doesn't act, your pro se complaint is based on ineffective assistance of counsel and a conflict of interest, which has impaired the obligation of contracts due to corruption in the bar. Because if you call the judge or the prosecutor as a witness in your case, they can't testify because it would be a member of the bar testifying to a member of the bar.
Yeah, and that's true, and because that falls back on the conflict. See, that would be a conflict of interest, and they can't do that. So yeah, I mean,
they even went so far as to rename the baby after the cop that interfered with his mother's death investigation, and the cop that took him out of his mother's arms initially.
Oh, I remember you telling me that. I remember you now from the other. Yeah. So yeah, that's exactly what. The gentleman that was, by the way, thank you. That was very nice of you. That was very good information that you just shared with us.
Oh, sorry. My name's Mike School. I'd just been quiet waiting until today Mike kept before,
nice
but I haven't forgotten that guy. I got stuff in front of me that I'm waiting to tell him about because it's in those PDFs. The first PDF link that I sent to Ed, if you go to page 19 of that, right about the middle of it, start reading there. You can void official immunity for affirmative acts. So you want to look for combination in restraint of free trade, because you can't impair the Commerce Clause. And that's what the attorneys are doing by saying you have to be a bar attorney to practice law in this court, and you don't. You have to demand they prove it in writing in the Constitution, which if you look in the U.S.
that
codes,
is so true.
There's codes in there that say that the courts cannot order you appointed counsel. I don't know it offhand, but I think it's 12 USCA something. But I'm listing it in my case because the judge ordered me appointed counsel or I go to jail. So I had to appoint counsel. So after I got out of counsel...
One at a time, please. One at a time.
Why don't you go after them for restraint of trade?
Yeah, that's where it needs to go. But you have to lawfully execute your instruments in front of it through a notary with the jurat form and then certified mail them. But I have a jurat form I mailed to Ed a while back. That it's called a witness executor jurat. So you can use it because it requires a written registered response. So if you do it correctly, you can lay everything out in common law. So you've exhausted your administrative process and you have to go into court. But when you do, you are the original court of record, because when you execute a document, you have the notary make a copy of the complete set of what you put together as your packet, and then you only send out copies, because then you've made them a third-party intended beneficiary, which they don't have any rights. So when you move into federal court under your pro se complaint, then the court has to construe your will. And so it's your first writing is the very most powerful thing you can do, because your pro se complaint is they have to honor it, because once you enter something into the record, they can't scrub the record. They have to honor it and protect the integrity of it. So that's our loophole in the system, so to speak, because that's like the door kickers in the Gulf.
Well, and you know something, Mike, also, which is, we forget, we need to ask for the master tape, because the master tape they can't alter.
Yeah.
So you want to demand.
Sorry.
Huh?
If there is none, you can't ask for them.
Oh, trust me, they have that.
They have it. You got to put it in writing.
But you have to demand it. Trust me, they have the master tape. The master tape is what is completely something different. Most people don't even know about the master tape.
If I may, Mike, you might want to look at Kalina versus Fletcher too.
Excuse me?
You might want to look at Kalina versus Fletcher.
What is it? I was just given ideas for you for family law. I'm not. I don't study family law.
Yeah, Kalina versus Fletcher says they can't force an attorney on you. It's a Supreme Court ruling.
Oh, okay.
Well, that's a good one to know. But yeah. So you also, if you do with this. Oh, go ahead.
Sorry. One of the things in Rich's complaint we did is address that fact, because attorneys are members of the bar, but a judge while sitting in office is not considered a member of the bar, but they still are. So it's a conflict of interest and ineffective assistance of counsel. So what you just said right there with that case law, they're forcing an attorney on you. So you do not consent to a magistrate judge because it's a conflict of interest. So that's all we have these days is magistrate judges, and you want an unrestricted common law grand jury of 25 or more of your peers. And the information you're looking for is you want to Google the Citizens Rulebook PDF and print that, and that's got all the case law on how the jury is not subject to a judge or a prosecutor except like a pro se litigant.
If I may,
Virginia Styles Manual. It's at West Virginia University.
Is it at the West Virginia University?
Google search from their search engine, it'll come up.
Okay.
Yeah, because you know what they're doing, because the judge is acting as a prosecutor, and the judge can't act as a prosecutor. That's where your conflict of interest comes in.
No, but the way you can establish that the judge is not the prosecutor or the judge is only the trustee is if you enter documents onto the record in court, and when the judge says, "All right, hand it to the bailiff," you have to instruct the bailiff. Bailiff, please hand those records to the clerk for entry into the record. Then have the clerk pass them on to the judge.
Right.
Okay. And then you've reassigned the rights.
That's true. Yeah, that's right, Mike. That's good. That's a good pointer.
Because the clerk is the adjudicator, the judge is just the trustee.
Getting back to your case, the Fifth Amendment says that's assistance of counsel. That's not counsel in chief. He can't be forced upon you.
That's true, and I'd like to add something to this point. It is a clearly established the principle of law that an attorney must represent a corporation. It is being incorporated and creature of the law. An attorney representing an artificial entity must appear with the corporation charter and law in hand. A person acting as an attorney for a foreign principal must be registered to act as a principal behalf. See Foreign Agent Registration Act, 22 U.S.C. 612 Esquire. Case is Victoria Robinworth versus Robert F. Kennedy, former President of the United States. And it says failure to file a foreign agent registration statement. That's why they went after John F. Kennedy. Okay, that's when he was putting together, what do they call that? Executive Order 11110 to go back to the original structure of our country. So House Resolution 192 would go back to be working for lawful Americans only. That was part of his executive order. And it states in it, before the court, jurisdiction, lack of standing to before the court is a felony. Pursuit of 18 U.S.C. 219.951 is a conflict of law interest allegiance in observed, and Mike knows this one too. See, the attorneys can only represent corporations. They cannot represent people. So if you are using your citizen name, all right, and you're still registered as a corporation with the House and Senate in an executive order of the Secretary of State, that's how they get away with this. I'm not a citizen, registered citizen, corporation.
Right.
I am technically, as filed in the state of Oregon twice, as a lawful American, as well as a lawful bloodline American. I wanted to make sure there wasn't a conflict of interest when I did my instruments way back in the 1990s for the Oregon State House and Senate, so that way it wouldn't be a conflict.
Well, you know what, Ed? You also, the instrument that we have put together regarding your case, since we had outlined so many case laws in that instrument, including, right down to the nitty-gritty, maybe you might want to share that with Mike and share that with the gentleman who...
Yeah, I'll share that with Mike at this point, but until I get it publicized and served, I'm not putting it out until it's publicized in the record of the Oregon State House and Senate.
Right.
Because in that way, they cannot try to do a conflict of interest statement on me.
Oh, I agree. Absolutely.
I want to nail him ahead.
Yeah, you don't want that guy up there on top of the dome there with the axe chasing you.
Okay.
Well, I make sure that I have arms because if he comes after me with an axe, I've been in a situation like that once in my life prior. So, I've been through that one. That's why I carry arms.
I got the the Illinois Styles Manual for the Supreme Court and Appellate Court of Illinois. All you have to do is Google Illinois Styles Manual, and it'll come up.
Did you hear what Dave said? He just did it. It's there. He's got it.
That's Illinois for the other gentleman, and he already told me how to get the West Virginia one.
Yeah, the
Okay.
West Virginia one I already gave you. It's at West Virginia University.
Okay. Well, you're certainly not going to get it out of the Supreme Court.
No, you won't. It's evidently they got it at the university, so you don't have to go through the court.
Okay.
Which is good.
But what the Styles Manual do, they give you the definition of words plus court cases that you can use.
Well, I know when I cited them for malfeasance of office and malfeasance of law and warned upon the Constitution under U.S. versus Will, their answer was to throw it in the garbage.
Well, yeah, but the one point that I brought up to you, you didn't file it in Washington, D.C. in the Judicial Fitness Committee of Washington, D.C., because the judges have to go through that. If they don't honor that, Congress, and if you service the Congress with that, Congress could stop their budget, and they do know that.
That's true, and that's why I was indicating about the motion to vacate. In other words, you're literally removing it, and you can.
So you're saying file a 60B?
If that's
a 60 what?
A 60
Rule
what?
60B.
D?
Yeah.
Oh, Rule 60B. Yeah, if the Rule 60B regarding your state applies to a motion to vacate, yes, that's what I'm claiming.
That's the federal rule. That's the federal rule.
Right.
Correct.
Here's one way you guys need to approach this. Go to your state constitution and look at your rights.
There you go.
If they are in violation of your rights under the state constitution, they can be hung for treason.
That's right, and that's why because believe it or not, when you look up your state constitution, like I did, it actually gives you it in the document itself. It tells you what to do, how to do it, and even cites case laws in those documents. I couldn't believe it until I looked it up myself. I was like, oh my God, it's in there.
I cited the state constitution in excess of 50 times, and the Supreme Court ruled that I had cited no law.
Well, that's
right. You cited administrative rules.
Right.
You didn't cite the law of the Constitution that has the authority that gives you the authority.
I cited the state constitution.
Right, but you have to. But you have to. What Ed is trying to say to you is you have to add the laws that back up what you're claiming pertaining to the Constitution and your rights. If you didn't add any law, then basically what Ed just referred to you and what the judge just you have to state a claim. You didn't do that. You understand what we're saying?
Claim. They had violated the state constitution.
But your claim was for what? Was it your bloodline?
If I may.
Go ahead, Mike.
Everybody's been declared civilly dead by contract, so you have to know how to word your responses correctly so the court hears you, because you have a capacity as the employer to the contract, and they are the employees, and they're bound by administrative rules and codes, and that's what we're trying to explain. But it's about just using a certain procedure to put together your case correctly, where they have to act because they have no other choice, or they destroy the record, and they're held personally accountable.
Well,
they
went into our.
They went so far as to hide conspiracy to interfere with justice.
But you have to comprehend what we're trying to say to you, sir. Like the gentleman Mike is explaining to you, you might have brought forth that claim. Let's put it that way. But it's how did you present it? See, if you, it all comes down to how you're presenting it. You can make that claim and you can use certain things or bring certain things to their attention, but it's what you're saying after that. You have to, in other words, they have to know that you're going to hold them accountable.
If I may.
Well, I criminally cited him. Who do you bring the criminal complaint to?
Well, you share your information.
Let me answer that one, and then we're going to give the floor to Mike. You bring your criminal complaint to the United States Marshals, to the FBI, to the Ethics Board. You file your criminal complaint in Washington, D.C. on the Judicial Fitness Committee.
Right.
And you have a Judicial Fitness Committee in your state that you need to file that in violation.
But the Judicial Fitness Committee in West Virginia is under the West Virginia Supreme Court.
I know that, but see, I know that. It's the same thing as Oregon. Every state is under that. But when they start realizing that you're able to start producing factual evidence, not hearsay.
Well, they threw out 28 affidavits that were brought under Evidence Rule 301.
They might have dismissed them, but they're still on record.
Yeah.
So you go back for the record. Go ahead.
That's another thing they did is they could prove that they altered the record.
Oh, we know that, yeah, you could prove it, and that's the one thing. We know how that one goes. You know, we've all been through that one.
And that's good if you can prove it, because some cases can't prove that. But if you actually can prove that, that's in your favor.
If I may.
Well, I could show documents with two file dates on the same document.
You didn't. I don't think you used your tools of discovery because it says presumptions. You have to revoke the presumption of the court. And Ed, I was going to say, Ed, if you have those charts I sent you, he needs to read the one on family law and contract law. Because professional responsibility, those three right there, he should be able to understand his case. And then you also have the first PDF email I sent on the Title 1983 litigation. That's got everything you need between those things I just mentioned. That once you read all that and let it melt, and then read it again, file a pro se complaint, and I'll review it for you and send it back, and then file that in federal court, and you'll get a different response.
Yeah, I agree.
Okay, because I already tried in 1983 and went nowhere. They separated.
Well, it's how you present it.
Yeah, but which case did you cite? Sometimes people win just because they want to get out of the way and their rights were deprived, but it's a hollow victory that's on the record.
Well, I cited over 63 different cases where judges were liable for their conduct, and they just they said judges weren't liable for their conduct.
Well, yes, they are.
Yeah, we all know that.
You didn't rebut the presumption.
Yeah, the judge is not the court.
That's right.
He's an
judge is not the court. That's true.
Well, I'm sure I cited it. I'll put that together, all the documents I brought, and get them emailed to you as soon as I get some email up here in Texas.
Yeah, once you do that, I'll pass them on to everybody.
Yeah, I was getting pretty broke, and I had to do something. I was laying in the grave and waiting for the sides to cave in when it rained, so I had to go make some green.
Well, now you know why. Now you know why. What the democracy movement? now you know why the democracy movie is doing what they're doing.
Well, you know, the first democracy recorded in history was when Moses went up the mountain.
Yeah, but that was by a foreign country.
Yeah.
Yeah, but
that has nothing to do with we, the people of this country.
And you know how well that worked out.
Go
ahead, may I?
Okay, what West Virginia? What these folks don't understand is that you're talking about West by God, Virginia.
Yeah.
Wasn't there a song about that?
I can say it another way, but I'm on a public. I'm in the public.
Well, that's what it is, right? They call it West by God, Virginia.
Do they really?
Well, yes, they do.
That's a slang in West Virginia.
Wow.
Yeah.
And I wonder. I got to get going, so I'd like to find out if the guy from Chicago. Can I get his phone number? If he's still on.
You have mine, Mike, don't you? Go ahead and give the guy. Yeah.
We've got his email, don't we?
Yeah, I guess he's not still on. I guess.
He's got my email, so we'll see if he sends anything.
Oh, yeah.
Well, you have my phone number, don't you, Mike?
See, this was exactly what I was talking about on the call last night, Ed. We need to brainstorm the problem.
Mm-hmm.
We solve it.
Yeah, we do.
Mm-hmm.
May I still?
Yes.
Yeah.
How about the West Virginia caller? Would he give out
You got my number again, yes, 304?
Oh, no, that's Daniel?
Yes.
Okay, I got you, Daniel. All right.
You have my number written down? Okay.
304-992-1592?
Yes, sir.
Got it. I yield.
And I go back into my session and work at 10 hours a day for the next 2 weeks, starting on the 26th.
Yeah,
I mean, it's just amazing. It is just amazing how much fraud and RICO is going on. And, I mean, and we have senators and governors in all 50 states that are allowing this BS crap to continue. I mean, we have to really... Sure they are. Sure they're
Yeah, that's how they're making their income.
Right.
Yep, nothing like that.
And the thing I discovered that's most appalling about that is they have a system of protecting their individual vested interest from the public.
Of course. No, they do not. They may think they do, but they don't.
Well, that's true. I agree there.
There's always someone higher. Always someone higher. And
that
we
is
will
true.
Find that someone. We will take care of this situation.
Well, we have found it, and that's our Constitution.
Right.
And the laws that back it up.
Find the right court to file it in, and I think that's the U.S. Court of Claims.
Yeah,
Pittsburgh, the Court of Pittsburgh. Pittsburgh, you talking about?
Yep.
Yeah, I think that's the only way I want to do any good.
Yeah, I'm going to have to agree on that note. I mean, it sounds like you've done an awful lot. I mean, it doesn't sound like, you're all that unknowledgeable as far as what you've done. I mean, but, sometimes it's the little things that we overlook because we're so focused on the big stuff. And the only way we would know that is by looking at and see what you presented. It's a possibility.
The real kicker in the end run was that they held us in abuse and neglect after the defendant was dead and conducted adoption in secret in another case number.
Ooh,
We've never allowed access to the adoption case.
Wasn't West Virginia one of those states that seceded? Seceded?
West Virginia is a military state that was taken away from Virginia in 1863 and set up under martial law.
Well, we're all under martial law.
Yeah, but what I was saying to you was not Virginia or West Virginia or both part of the secession?
Well, Virginia was, but they took whenever the Union Army conquered West Virginia, they took it back to shield the District of Columbia from Virginia. They separated West Virginia from Virginia unlawfully and set it up as a military state.
Okay. Has there ever been a declaration of peace following the war between the states?
No.
Ooh, that's a good point.
So you're still at war.
Excuse me.
This is going to bring up some issues.
If I may.
Yeah.
Mike.
The law of the flag governs the contract. So when you go to you got to locate words and phrases and look up the law of the flag.
Law fraud?
Well, if you go to uscivilflags.org, you can buy a couple of civil peace flags and buy one on a little stand to take to court with you. And I have a civil flag patch. So we've got de jure militia units around the country that are now switching out the fringed flag to this flag as a de jure a militia in a de jure status of peace. So we're occupying the offices lawfully. But that way, when you go to court, you can use the flag to your advantage because the law of the flag governs the contract. So if the judge, you have to just object to everything they're saying and reject it as fraud because you as the living person are the third-party beneficiary to the contract.
Eisenhower's Executive Order 10834 relating to the gold fringe flag as color of law fraud.
Well,
the flag in a courtroom carries a 1-year prison term, but will the sheriffs uphold it and arrest the judge?
There's one flying in the sheriff's office.
I know there is. That's the reason why I'm saying. You see, the sheriff, everybody, the corporation has no jurisdiction over you, period.
Well, I pointed out to this sheriff here in this county here in Texas, first thing I pointed out to him was that I was not in the state of Texas. That I was on Texas state. I was not in the state of Texas and never intended to be a corporate member.
Wow. Well, I would recommend that the those that are on the call to look up barefootsworld.net and go to that six page document and read it. And then I'd like to hear your input on it next week's call, because it has it cites a lot of stuff in that document that's regarding that 6-page document, and that's what David was wanting me to share with you on the call. And I'll tell you, when you read it, you're going to be amazed what's in within that 6-page document, and it might just help you with what you're dealing with, and you might want to apply it to some of the things you're addressing as to what you need to do. And I agree with Mike as to him, what he's claiming and what he's saying to you. I think there's certain things that you haven't done that maybe Mike, when he sees your document, he might discover what your next move might be as helping you address your state as to what you're dealing with.
Well, I don't know how to get around all the fraud. When you have 2 file dates on the same document?
This is a violation of your civil rights. There is no way in the world they can deny that at the federal level. You need to file a civil rights complaint.
Yep, and you need to file a motion of removal and get it in federal court regarding them violating the laws and also the laws pertaining to the Constitution. It only takes one law that the judge violated regarding your due process rights to get it moved into a federal court.
I have in my possession one copy of the writ of mandamus that's stamped received September 3rd, 2014, and the ink's bled through the back of the page. I have in my possession another copy of the index to the writ of mandamus. It's stamped filed September 22nd, and that one is certified by the court.
Well, you have the evidence of fraud against you, and that at any of your documents, did they alter your name from the way you filed it?
Not that I know of. I haven't looked for that.
Well, you need to.
You signed it. If you went into court as a man, your name upper lowercase, and they brought it back to you as all caps, that's identity theft. You got them right there.
Well, and not only that,
I filed all the documents in her name.
But listen to what
legally married. We're lawfully married, not legally.
But listen to what David was indicating. In other words,
I heard what he said. I heard what he said.
But did you understand?
If they modify the name, then that's identity fraud.
If they modified any of your documents,
right,
it's fraud upon the court. Fraud upon you.
Well, there's plenty of documents they modified.
All right. The minute they modified them, where was their power? Did you give them power of attorney to modify those documents?
No, and I also, and there was also,
they damn well want.
And there was also the letter of May 8th from Terry L. Farley, set up a series of slanders against Nancy that was held in secret until September the 4th. And it was written CC to the prosecuting attorney and to the judge, and they committed conspiracy to interfere with justice. And when they when they attempted to file a criminal complaint on that.
Well, I'd like to see your documents. I would like to see, because I can tell you right now, there's a lot of things I would be doing regarding what you're telling me. So I would like to see what you've done, and I think between Mike and us reviewing your case, I know, and I already know by what Mike's already told you, there's things that you need to do. We need to, in other words, we need to address some things. And I honestly believe, like what Mike was saying, I think that we should be able to make some headway with your case. We have to see what you've done. We have to see what they've done, basically. It's not so much what you've done, it's what they did. We have to see what they did and how they modified and what they changed. And if if you're telling me what I'm hearing right, that you're going by two different case numbers, well, right there, that's a big conflict. Big fraud upon the court. I mean, there's so much I'm hearing, but we have to actually see their documents. We have to see what they've done, how they responded back to you, and all that stuff in order for us to move forward and really help you. Because all we're doing, we're just speculating. We can't speculate. We have to really know what's going on. And I can tell you right now, there's many things we can do, but we have to see what they've done in order to act. And you also need to do like what they were just telling you to do. You need to file complaints with other divisions pertaining to the judicial misconduct and things like that. You need to move forward and do that. And if you haven't done that, you need to do it.
Yeah, I'll have to sit down and do it. Right now, like I said, I've got this brief respite, and then I go back to working 70 hours a week, 10 hours a day.
Right.
For 14-week periods, and then I go back into I get a week off every third week.
Well,
when do you have to respond to the court? What's your date on that?
Oh, it's all been thrown out.
Oh, okay. So good. We get to start over.
That's all been thrown out. The federal court
and screw them.
The federal court separated the evidence from the case and said the case was frivolous without the evidence.
Well, Mike, if you're on the call, I think you know how you sound like you know what you're doing, and I like it. And I mean, I already know what I would be doing. There's a few things I'd be doing besides addressing the complaint, and I definitely would be moving for a motion of removal or a motion to vacate, or both.
60B.
Or both, huh?
Yeah. That would be a motion, a 60B motion.
Right.
Motion to vacate.
Oh, absolutely, and you can and also a motion to removal, and of course before you do all that, you want to get all your documents and to get gathered up so we aren't missing anything, and go from there, and of course do like Mike said, we need to you need to address documents as complaints. You got to move forward on that. So yeah, there's a lot of things that can be done that need to be done.
Yeah. Well, I appreciate it all. Thank you all very much for your time. Yes.
I'm the gentleman from Chicago. I'm from Chicago, and he just sent me a text. He told me to give you guys his number since you wanted it. I'm still on the call.
Oh, good.
Give me 1 second. Let me know when you're ready. Let me know when you're ready.
The gentleman.
Okay, you said #1. Well, he's off. He hung up. I sent him a text and let him know that you guys had wanted his number. And he told me to go ahead and give it to you.
Yeah,
Okay.
do you have my email?
Yes, he has it. He has it. I know he has it.
Okay, send it to me email 3 times and I'll pass it around.
Okay, definitely. I'll let him know.
All right, because see,
Okay.
I respect the main point, and this is where others do not respect when we do these conversations too. Remember,
Right.
the most important thing is that we have to protect
Gotcha.
one another's First, Fourth, Fifth, Sixth, and Seventh Amendments that
Okay.
give us our lawful rights, not legal rights. Because if you're a legal citizen, you have legal rights. If you're lawful, you have constitutional rights.
Gotcha.
You know, and even the federal marshals will even tell you the same thing.
Will do.
Now, can we move on? Let's move on. Who wants to hear about some fatal steps? Now, this has to do with what Commerce is doing and Congress is doing, and of course, this is based on some history. If you want to hear it, but I have to. It's kind of funny. Now, this is also in Barefoot's World's Network documents, but he is called War Powers Act as of March 9th of 1933. And this again falls under Title 12 U.S.C. Section 95A and 95B, because remember it has to do with security. And when you Google that up, you'll find out where we come in as we the people. When you cite that statute, but it's kind of funny because it says this act states that during time of war or during any period of national emergency declared by the President may, through any agency that he may designate or otherwise investigate, and of course now this has to do with regulate, prohibits, under such rules and regulations as they may prescribe by means of licenses and otherwise. Sound familiar? Any transactions in foreign exchange, transfers of credit between or payments by banking institutions as defined by the President and export, hoarding, melting, you name it, earmarkings, gold and silver, coin and bullion and or currency by any person within the United States or any place subject to the jurisdiction thereof. Now, what they're referring to in there is regarding the executive orders. That's where they're going with that also. Now, when you look that up, now it's kind of funny because keep in mind when I was citing and I was looking up these certain codes and statutes, I came across that information and I printed out the whole document because I was so impressed by it. So it's funny now, this isn't my document that I'm reading, but he is citing what I discovered. So he's actually citing it in his own documents as to him talking about the Constitution. So I found that very knowledgeable and delightful, because he was talking about something that I not only that I discovered, but he discovered it. So that made me feel good, and it makes all of us feel good, because that means that what we're talking about, evidently we're not wrong, because if we were wrong, he wouldn't be making those same claims. And he made the same claims in his document. And this document, his work goes back, oh my gosh, it goes back, I think, actually before 1969. But he talks about President Nixon signing a declaration, and it was all because he was a president. And he's addressing an executive order, which is 11647. And I mean, I was surprised because it's talking about, it's talking about the designation, no, hang on, wrong line. The Federal Registry, which was of February 12th, 1972, and it's through the authority vested in him as a president of the United States. And President Nixon established a federal regional council for each of the 10 standard regions. It states that the president shall designate one member of each council as chairman of council, and such chairman shall serve at the pleasure of the president. The fact that the state, with the capital S now, borders have been destroyed to create a 10 regions instead of a 50 union state is something the government doesn't want you to know. So this
well,
is
yeah, but where's the 50 union state? We only have 48.
Well, he's talking. Well, that's.
I'm just saying, Hawaii and Alaska is not part of the union state. They didn't join in until the 1950s.
Correct.
There is a separation,
wait a minute.
when you go to court.
Now remember, he was addressing this document before then, because this his history that he's referencing off of goes back before that time. So that could be why I don't know, Ed, to be honest with you. All I'm saying is he's talking about the 50 union states.
If I may, Michelle?
Yeah,
that's
sure.
why I always write near beside that zip code.
Yeah, and then you put it in the brackets on each side of the zip code.
Yeah,
right?
Because I write near, because I don't live in the post office. That's the federal district. The post office is the federal district. I don't live in the post office.
Yeah, that's
under federal. That's under federal law.
Mm-hmm.
If you get in an altercation in the post office, they call the federal postal police.
Mm-hmm.
If you get in an altercation across the street, they call the sheriff.
Yeah, that's true.
Okay.
Yeah.
Okay, that's a federal district. You're on federal property.
Mm-hmm.
When you go or federally leased property when you go into that post office. That's the reason for writing near before that zip code.
Well,
and putting it outside of the box. You always put your address inside of a box.
Correct.
And put the zip code outside of the box. So that
I thought it was the other way around. I thought it was the zip code that went in the box and your address went on the outside.
I always box my address. Make it a document unto itself, an instrument unto itself. That address is my address. Everything outside that box is not my address.
Yeah, good point.
Okay, that is a good point. And you know what? Now, Ed and David, remember the autograph document that I sent you that had the border around the whole page? That's what he's talking about. And I shared an autograph document as pertaining to our instruments. It was I don't know how I found it, but I found it and I kept it. Well, anyway, I scanned it into my computer to share with anybody who wants it. So I have it on my computer. David and Ed have it on their computer. They'll have to share it with you. But that's a good point, because that's exactly what the autograph page did as to our autograph pertaining to our signature, as to attaching it to our instrument.
Yeah, it's outside of the instrument. That the location that I'm actually my address is Daniel Ray Beeler.
Mm-hmm.
But all that other location is included in that box. And then that zip code, that federal district, it's near that federal district. In other words, I can get out.
Code.
What?
Which is your zip code, right?
Right. And that's the federal district.
Right.
That identifies a post office. It doesn't identify anything else.
Mm-hmm.
But that federally, Congress may create from time to time federal districts, and they fall under Article 1, Section 8, Clause 17
mm-hmm.
of the Constitution, just like the District of Columbia, and they're exempt from the Constitution for the United States of America.
Wow.
So if you put yourself living in the post office, if you attach yourself to the post office, then of course you're in an exemption from the Constitution.
Wow.
Well,
now that just go, you know, that just
boxed in. When I write like Arlington, instead of just Ohio, I put Ohio State, and then I square box, or I put near, and then square box the zip code.
Yeah, that's how I do it.
I've been doing it just the opposite. I've been putting everything that pertains to me in the box and putting the federal stuff outside of it. And by the way, I do write Texas State or West Virginia State, wherever I'm at, and I write the state in all capital and then I write USA with a lowercase u.
By the zip code?
No, West Virginia State, USA.
Oh, I
and
see.
That's a lowercase u. That's the United States of America. United being a descriptive term, not part of the name.
True.
And but I put the zip code outside of my address, and I write near before it because it's near that federal district.
Yeah.
The federal district is within the state, but the state is not within the federal district.
Well, I've also seen people address it as care of, you know, regarding their address, and then they put in the zip code in brackets, and then they, like David is claiming, and they write near. So, yeah, sure.
If I may, when you address it to the facility, and then put care of the individual capacity, which is their name.
Yeah, that's a good point, too, because when I do my mailings, all my mailings I have sent to me care of, to me, near Toledo in Oregon Territory. I don't even put the word state on it. I put Oregon Territory, so that way it's not a conflict of interest.
If I may.
Go ahead.
By the way, Ed, I can show you an argument I had with the Oregon Tax Court. I was arguing with the senior assistant to the Attorney General, and I asked her to admit or deny that the state of Oregon is not a federal holding as described in Article 1, Section 8, Clause 17 of the Constitution for the United States of America. And she came back and said that they must, and therefore the state of Oregon is bound to the Constitution of the United States of America. And they came back and said they must comport with the Constitution, but denied that they were not a federal holding as described in Article 1, Section 8, Clause 17 of the Constitution for the United States of America.
So they're claiming to be a corporation.
Yeah, they're saying they're part of the District of Columbia.
Right. But see, District of Columbia, and that needs to be written and stated, District of Columbia is only in 10 square miles and cannot have any effect outside of the 10 square miles, even though that they increased their mileage up to 25 miles. I think that was in 1990. And
well, all the federal holdings part of that, Ed. Guam,
no,
Puerto Rico,
I know. Yeah,
Samoa,
no, we're on the
Virgin
same
Islands.
path. Finish. Go ahead.
Yeah, the Guam, Puerto Rico, Samoa, the Virgin Islands, and all that. All the federal holdings is under Article 1, Section 8, Clause 17 of the United States, including the post office.
United States Incorporation.
Yeah.
Just to clarify for people.
Including the post office, by the way.
Yes.
The post office is a corporation. Okay, it's part of the UPU. The UPU is what, a Swiss account or Swiss organization?
Yep.
That's a foreign entity. So the post office is a corporation, U.S. corporation. So they have to be made up of law and statute. They can't violate the Constitution, the supreme law of the land. And they have no legislative authority to alter the Constitution.
Well, my comprehension of it was that they were exempt from the Constitution.
No, they have a contract with us, we the people, that they have to honor it.
And the
But
thing
Congress has exclusive legislative authority there.
Yeah, oh yeah, Congress does. They cannot sit there and turn it over to. It's like when they signed the post office over to Sweden in 1972. Okay, 1972 is when they signed the post office. That's when all of a sudden the stamps went from 8 cents to 12 cents. All right, because they were allowed to raise it, but they're not allowed to raise it in our country for us against us. That's why I have, and I do, beside the stamp I got, I have mailed stuff with a 2 and 3 cent stamp on it, and they've got there with no issue.
Well, you can still do 1.5 cent mailings.
Oh yeah, you can do that because that's still under federal administrative law that they couldn't change. And see, that's the point. They couldn't change the structure of it at all.
I believe it was 1861 was the last increase in postal rates.
I think that it was right. I think it was a little bit after that was the last one because I think that's when it went to 2 cents.
Well, I thought 1861 was 1.5 cent mailings for up to an ounce.
You know, no, but see, the thing is that's why, to my knowledge, is that during the Civil War they raised it to 2 cents because nobody had 1.5 cents to put up. They couldn't do that to divide a penny.
Well,
yeah, that makes sense.
Half-cent pieces in. They had half-cent pieces. Sense?
I think you can mail a letter for 3 cents.
Mm-hmm.
And there's nothing they can do about it. You put 3 cents on anything.
Yeah, it is 3 cents because you want to know why? Because they pull the same scenario with the junk mail we get. I'm sure you guys have gotten those, you know, and you open up the envelopes and they have their envelopes inside the other envelope and they have 3 cent stamps on them.
Yep.
Have you seen that?
Yep.
Yeah. So it is a 3 cent. It is a 3 cent stamp. And they put those 3 cent. They put a roll of 3 cent stamps on their envelope because they want to hear back from you.
Mm-hmm.
Yeah. So yeah, it is a 3 cent.
Anyway, that
actually we could
post office is part of the federal district.
Mail fraud because they're overcharging us.
Mhm.
That's extortion.
Sure is. Well, I've been doing it like I said, I put my name and my address, but then when it comes to the zip code, I put it in brackets and I say near.
Yep, I do too. That's the way I've done it for years.
And so I really don't think there's we basic. I mean I don't know. See, I have to say that. I mean I understand where you're coming from, how you're addressing the document, but that also plays into the autograph part because your name and your address would be kind of like the autograph part. And then you're putting you're putting it in other words, you're putting your name and your address under a border, which is another way of claiming that's your district, you know, or that boundary. That's your boundary by putting the border around it. So, I guess it would be the same. I don't know if it's wrong or right. I mean, I can't say that it's wrong either.
It's one that may take some investigation to make sure.
Yeah, that's one. Yeah, I have to agree on that one. But I have not seen anybody do it the other. I mean, because basically what you're doing is you're flipping it. We're doing it the other way, and you're doing it. You're doing the same thing, but you're just flipping it. You're putting your name. You're putting your name and your address in one category as claiming that's your boundary, and then you're telling them with the zip code that's their boundary. I mean that's what you're claiming.
Right.
So I don't really think there's. Yeah, I don't think it's. So I'm going to say that I don't think it's the way. I mean the way you're doing it and the way we're doing it is wrong. I'm going to say that we're both doing it correctly. It's just that You're reversing it. You're claiming the zip code is their boundary and your name and address is your boundary. We're claiming. Huh?
Yeah, I'm saying this is mine and that's yours.
Well,
Right.
Correct.
If you look at BMM 602 at 1.3E2, zip code not required.
Yeah. So I think you need to do it the other way around. I think you need to do it like we're doing it, and that's why you put near and you put the zip code in brackets, because in other words, you're saying the same thing. You're saying that this is my district area and this is your district. Well, so you're really saying you're claiming the same thing. You're saying the same thing as to what you're claiming, but I think
what Dave just said too about if you put that USA on there, it's foreign mail.
Mm-hmm.
You look at foreign mail manual. If you put USA on there, it's foreign mail because it's outside of the U.S. And those zip code is required, but they'll fight you tooth and nail on it. So
I don't know. I use it all the time, and I don't have an issue.
Yeah, I was just going to say, me neither. I haven't had any problems either.
I shook up the Postal Service in Arlington when I advised them about that zip code not required. They had a sign up that said local zip codes, out of town zip codes. Those zip code signs came down.
Wow, that's amazing. Now let me ask you something. Because we're talking about of the United States regarding our address and our zip codes and now what if you're dealing with?
It's not ours, Michelle. It's not ours. It's theirs.
Well, it's theirs. Now, how do you go about addressing a address per se if it's like international law? International meaning that's not of the United States, it's out of the United States, and you're dealing with a foreign nation. So how would you address it that way? The address.
I'm trying to remember how I sent mail to the World Court. I think I left zip codes and everything intact, but mine I put near and near 45814.
So in other words, you put yourself in the bracket like what he just did.
See,
or was claiming.
They're a government entity, so the rules apply different to them. So if they show a out of country zip code and you're addressing a government entity, then you leave the zip code as is, without any brackets or anything else.
That makes sense.
Into their jurisdiction.
Yeah, that's a good point. That actually makes sense because.
If I may, Michelle, if you put USA on it, it's foreign mail.
Mm-hmm.
It's foreign to the U.S.
Okay.
And the postal system is under the U.S. That's federal territory.
Okay. So you actually write. You actually write the
USA. USA on there, yes.
Oh, okay.
I just
learned something then.
West Virginia State, and I write. There's no WV there. That WV is a federal district.
You spell it out.
Those two letter abbreviations, those are federal districts. Those are congressionally created districts.
Well, you know something. Now that we're on that,
the abbreviations anymore. I spell out the state like Michigan, Michigan State, or always add the word state after the whatever it is.
So do I. I don't send mail to corporations. I don't send it to the state of Washington. It's Washington State, USA.
Well, here's something interesting since we're on this subject. Let me read this to you and then get your response. This there is no constitutional jurisdiction for the federal government to legislate for a municipal government in a union state. And then it goes on, usurpation of the state jurisdiction can only be achieved by conspiracy and fraud on the part of our duly elected public servants. It stands to reason that if there is no constitutional jurisdiction for the federal government to legislate for a municipal municipal government in a union state, there is also no jurisdiction for a federal bureaucracy to legislate for a municipal government in a union state, which is the small s, as an example. Now he's talking about what we're talking about here, and he says as an example, the EPA. Now keep in mind when he says EPA, he's addressing them in all caps. And the DEA, he's addressing it in all caps, and the IRS, he's addressing them in all caps, and the FBI, he's addressing all in caps, etc. Then he goes on to say...
all caps means corporation.
Correct. Then he goes on to say, have no constitutional authority to legislate in a union state. Now, he uses the union state as a capital S. These are agencies of the federal government having jurisdiction only on federal territory. This is something and he goes on again, he says this is something your government doesn't want you to know, meaning the branches of our government. So I
got a question about that, Michelle.
Mm-hmm.
Isn't the FBI under the Department of the Treasury, IMF, London Town, City, State?
Yeah, I believe so.
The IRS are a division of the IMF, which are foreign entities. There's never been an organic act of Congress creating the IRS as a government agency.
And that's why he uses them as an example regarding the territory, the federal territories, or the territory. Then he goes on to say, demeaning the authority of elected officials and replacement of these officials by appointed federal administrators. So now he defines them in this document as federal administrators is a clear and present danger to representative government post by federal regional government outlawed by the Supreme Court decision of January 13 of 1982. And he cites the case, I have the case number, and he goes Community Communications Company, Inc. versus City of Boulder, Colorado. And then he goes on where he's talking about the 10 regional capitals were dismantled by President Reagan, which was an executive order, and he cites that executive order, which goes back to February 22nd of 1983. But what my point here is what he was indicating, and where he goes with this, because I'd have to flip the page, but where he's going with this is when we address our paperwork, for instance, he's saying that we are supposed to address it in lowercase, like we would do our name. In other words, the first letter is in capital, but the rest of the letters are all in lowercase. So what he's indicating here is by you citing, in other words, when we address our mail, and the addresses, meaning as to the states now, when we put the two letters, because most states are 2 letters or 3, right? And what are they? All caps.
No, Michelle. A state is never 2 letters. That's a federal district. If it's 3 or 4 letters, then that is an abbreviation, like it's in the old dictionary.
Right.
But the 1963 2-letter abbreviations that were set up by Congress set up a series of federal districts. You never use a 2-letter abbreviation, ever.
But that's no, we don't. But that's what they do. Is what I meant as to when they address the states, because that's what they did. They changed it. So what they're doing is they're addressing in other words, they're addressing the states as corporations. When they address right.
That was done in '63.
That was done in '63.
Along with the zip code thing. The zip code is set up for inter-office communications between federal offices and federal officers.
Mm-hmm.
Back in '63, I remember it.
Well, he's also citing a year here as to 1982 and 1983. Well, he's also citing an executive order, which was President Reagan. President Reagan filed an executive order on February 12th of 1983 regarding the districts as to the federal regional government. But now he's also stating here that it was outlawed by the Supreme Court decision.
Okay, so the federal regional government. The regional districts still exist.
Correct.
Okay, Dave's in District 6, and right now I'm in District 2, and I mean, I'm in District 5. Pardon me. I just left District 2, but the zip code districts were set up as federal districts, and that
brings up a really, really good point.
Yeah, he does.
If
he really does, because
are electing a representative to Congress to represent you and your state, why are you therefore put into a district, a federal district? You're electing your official from the state of Ohio to represent you, not a federal district. This redistricting crap is fraud.
I'm agreeing.
It is, because it goes back to England, because that's what they go by as districts.
Well, now keep in mind he's also referencing off of the Union. Remember the Union state.
Mm-hmm.
We have the Union state, and then we have the non-Union state. And so the federal grant, because he says here the federal grants to the state, meaning with a small s, governments are the fuel which make the regional engines go. And of course he said, he says it blackmailed. The as to the Union states are blackmailed.
Yeah, basically you're being kidnapped.
And and he says here,
put a zip code on something, you're being kidnapped.
Yeah, and then he goes on to say in this document, through the withholding of federal funds. If the federal legislation is not enacted into state law, which is the capital S, and that's where we're talking about between the difference between the state and the federal, thereby opening the door to a power base for the silent revolution of a federal regionalism.
And there's several Supreme Court rulings, and I can't cite them off the top of my head, but it talks about that very clearly in several of the Supreme Court rulings.
Well, and you know something?
That's legislative fraud, and it's been going on for a long time.
Well, you know something? That's that. Well, guess what? What we're talking about here is where the democracy movement is coming in as to the regarding the privilege. They want us, and that's where martial law comes in.
Yes. They want you completely without rights and everything a privilege.
Right, and guess what? I just, back in 2005, believe it or not, back in 2005, there was a video that Ron Paul, our senator, had addressed in a YouTube. And he was actually, believe it or not, it's actually a good video to watch, and I have it on my wall on Facebook. and I reposted it just today because I went back and I listened to it and I couldn't believe it. But you know what? Now he's warning us in the video, but he's talking to Congress at the
same thing.
Right, and he's in other words, he's telling them, hey, Obama just addressed an executive order, and he called for remember that, and he called. In other words, he addressed a martial law. He addressed martial law, and so Ron Paul is addressing the Senate floor.
There has to be an imminent danger that the administrative functions of government will fail. So show me in the United States where that's ever happened.
Well, and just like when we were talking earlier, David, about the going back to on March 9th of 1933, which is the War Powers Act, and that's where it spells it right out what they're supposed to do, what they're supposed to be following, and that's where I went, and that's what I used when I petitioned the court, and that's the law I cited, and I told the judge I was holding him accountable.
Well,
and he got so.
Lincoln used the War Powers Act when the South attacked Fort Sumter. However, the War Powers Act only applies to when a foreign nation attacks the United States. So that was fraud and inducement.
Mm-hmm. True. So well, now wait a minute now, because that's true, but there are also laws there or references made under that Title 12 of Section 95A and B. There's rules and regulations that pertain to we the people, because remember, it has to do with the Constitution.
Right.
Now, they're not supposed to be addressing those executive orders now, because that goes back to 1933. Well, we're not at war. That has to, like we were talking earlier, that has to do with a national emergency.
In 1933, we weren't at war with anybody. And Roosevelt lied. He said there was never a declaration of peace following World War I. Well, where was he at the Paris peace talks?
Correct. Well, I never.
Michelle, are you familiar with FE versus GE?
No. I mean,
in that ruling, the Supreme Court ruled that judges do not rule on statutes and codes. The administrators rule on statutes and codes.
Mm-hmm.
And
man, okay.
Say what?
I'm giggling.
Law.
That's right.
Say what?
They're not law.
Judges only rule on law. Statutes and codes are not law. That's for executive administrators.
Correct.
Now, how often do you go into a court before a judge? If these are not courts of law, they're administrative courts, you're only going before an executive administrator. Right.
Well, that was my question when we were trying to help the gentleman that just got off the call with the grandchild. Remember, I said,
That's me.
Oh, I'm sorry, that's you. Okay. I'm sorry, I had you mixed up with somebody else. Okay.
The guy from Chicago left, I think. He might be still in the background, but I'm getting ready to email everybody his stuff. I just got it, so I'm getting ready to do that.
Okay.
Well, that's why
I'm going to about ready to lose the battery. It's midnight here in Ohio.
Okay. Oh my God, yeah, it's midnight here by me.
I think we need to wrap this up because people have to go to work tomorrow.
Yeah. Why don't we do that? I'll let Michelle have an ending thought here. Then actually I'm going to let Mike have an ending thought. And then I'll turn it over to Dave, or I'll have my thought, and we can let Dave in tonight.
Okay. Go ahead, Michelle.
Well, what I would recommend is I would like the people to go to the website, barefootsworld.net, look up that 6-page document that I'm talking about. I would like for them to read it themselves and then make some notes on it, and let's have a conversation on it for next week, because there's some things we didn't touch on that I think are really good to know. Also,
I gotcha, but did you make a note of that, please?
Well, what do you mean I made a note? I
make a note of what I'm saying of the ones we of the ones that we didn't get into. So make a note if you remember what we need to bring up next week is what I'm saying.
Oh yeah, sure, absolutely, no problem. I mean, we only touched like just part of the page. That's why I'm asking for those that were on the call tonight to read it themselves, and we can actually go through the whole thing on next week's call, because there's a lot we didn't touch. And the reason why I'm asking you to do that is because it actually gives us answers to the democracy movement, why they're doing it. There's a lot here that we didn't touch, and I'm telling you, it's amazing. And it might be even good for like those that are in the states that are really having a hard time because of the administrative procedures, the way they're addressing their courts now. They might be able to use some of this material to help them with their case. And I think it would even help Mike as to what he wants to do and help, in other words, after he gets the documents and reviews them, he might see some of the stuff here that might
we'll see. I'm getting ready to email some of this stuff.
Yeah.
I'm not sure if it was, because I think it's from the guy from Chicago, so I'm getting ready to get that. But finish up, Michelle, because we should end it up.
I'm done.
Okay.
Actually, I'm done.
Mike, if you're still there, I'm going to let you throw a couple words and thoughts out.
Thanks. This was a good call. It was interesting to listen to this stuff tonight. My website is citizensactionnetworks.com. If you get time, go check it out and click all the links, because there's a lot of stuff. There's a lot of information on commercial liens, which lead to equitable estoppel for failure to perform services in a contract if you know how to enforce it, and that's what I'm helping Rich with his pro se complaint in Washington Federal District Court right now. And that the guy that's from Virginia, that's what we were talking about earlier. Ed's got that PDF on Section 1983 litigation that's got every key case that they look for, pro and con, that the attorneys put out that's not supposed to be published. And so he's got a PDF to that for you. And then that family law chart too, and the contract law one, and the professional responsibility. Because if you go through the documents tab on my website, it's all about ethics and holding the public servant accountable and liable. So what's been throwing a fire under them lately is doing a FOIA request on their Foreign Agent Registration Act statements at FARA.gov. Because even though a judge is not considered a member of the bar while sitting as a judge, they still are. So they still have a FARA statement on file. So if you prove they're a bar attorney, it's a conflict of interest for ineffective assistance of counsel, and it could be a cause of action for your RICO complaint if you put together the pieces to enforce it.
Well, can I add one thing real quick to you, Mike? That's why you asked for a conflict of statement from the judge.
Well, I'm learning that the writs and declarations have a lot of power, so you have to use your interrogatories and depositions in your favor, and that's one way that right there that you're talking about.
Well, now, Mike, let me ask you something, and that would also fall under the adhesion contract then, or the adhesion contracts, I should say, with the yes.
Well, with the oath is a quid pro quo performance contract.
Right, but I mean, with the adhesion contracts, they are in violation.
Yeah.
So.
Especially, well, right now, see, nobody knows about the third-party beneficiary. You're an intended beneficiary, and they're an incidental beneficiary. They don't have any rights. So if you know those words in the phrase right there, and it's in your contract, and you can throw that out there and enforce it in court, they have to run and look up the law and bring it back and show it to you in writing, or they're in violation because they're the bar attorney that can only represent a corporation, and a corporation cannot create an affidavit.
Mm-hmm. Well, and you know what, Mike, that's a good point, because you're right regarding the third party, and of course that's where they would be addressing violations pertaining to the adhesion contracts, because that would be a violation there.
Well, also, too, that's not quite a violation. That's criminal activity.
Well, it's both.
I know that, but see, violations what they use legally, and that's the point that I'm trying to get us to get away from that legal point and put in the lawful point that they're violating this under not only administrative rules, but their own contract that they're supposed to sign under their oath of office.
Well, that's where Mike's coming from regarding the third party. Regarding the third party, right, Mike?
Mike, you're right. If I may, Mike, you said something there that rang my bell pretty loud. You said a corporation cannot put forth a affidavit.
A corporation cannot create an affidavit. It's an incorporeal and a fiction of the law, and that's where Kennedy versus Rabinowitz applies, because the Foreign Agents Registration Act, and that's why they're required to register. So when in your writings, sorry, I'm having a brain fart.
I know, I do that too. I hate that.
In my writings, when I have notarized, it's not for use outside. Without the United States? That's what it is. Not for use in any foreign jurisdiction, i.e., without the United States, and that's in brackets.
That's a good point, Mike. I like that idea. What you're
if you
bringing
go to
forth here.
If you go to my website on the home page, there's a Second Amendment picture. If you click on that, that'll take you to the Second Amendment pro se lawsuit I filed with the state commander of the California militia against the state of California, the governor, for Second Amendment infringements. And it's got a lot of case law in there. So if you check that page out, it'll show you where corporations have no rights over living people, if you know how to put together the contract as a third-party beneficiary.
Well, that's true. And also, too, I've got the laws, too, that a district attorney is a hearsay witness and cannot enter any evidence under that, what you're talking about, Mike. And, we're on the same page because we know this, but go ahead.
Well, it's Trinzi versus Pagliaro. Attorney cannot witness, and the prosecutor's...
Well, in West Virginia, the prosecuting attorney is the statutory attorney for the state as well.
Correct, yes. They're all statutory attorneys, but they're not supposed to be able to deal with the law, that period, with anybody who's lawful. Now, if you're still registered as a corporation, that's how they go after people, because they're saying you're still registered. You have a driver's license. You have this. You're using a registration number for a phone number, which mine is different. You're using a registration number for TV or any other luxury items, because remember, those are called luxury items.
Well,
what I'm talking about, Ed, is something a little different. He's the statutory attorney for the Department of the State, for the Department of Health and Human Resources, for CPS.
Right, but he cannot enter evidence. The only one that could technically enter evidence dealing with your granddaughter is the granddaughter.
Correct.
Or the grandson.
They can't enter anything for her. She's a minor, so that way they have no authority.
Well, the caseworker that brought the complaint had never seen the mother, the child, or the backpack.
Yeah, no, I know. We discussed that. Yeah.
Well, that's what I meant, and that's also what I meant by the judge. I mean, the judge was acting as prosecutor. Judge can't act as a prosecutor. In other words, the judge is asking questions. Well, if the judge is asking questions, first of all, the judge just violated the Constitution, because the judge is acting as prosecutor, yet the opposing side, as the attorney who's going after him and suing him, is acting as a prosecutor. So they're both in other words, they're both acting as prosecutors.
Mm-hmm.
They can't do that.
That's true, and the prosecuting attorney is also acting in the judicial branch at the same time he's acting in the executive branch.
Not only that, as an attorney, it violates his oath of office, because all attorneys, yes, they do have two oaths, but all attorneys have to sign one oath to the Constitution of 1778.
Well,
and if you type in the bar license and ask for the bar license for your state, you'll see it will come up. They can't take that off. They have to go by it.
Well, statutorily, he's assigned to both positions.
Yeah, but he can't be because that's a conflict of interest, and not only that, that's
I'm aware of that, Ed, but that doesn't stop them.
No, I know what's going on, but see, when you file this stuff, this is what nails them. Because I mean, I've done this in Oregon where they just ran away from the case, literally.
Well, when I filed a writ of mandamus, they just dismissed it without cause. They refused to state why. They were dismissed it without cause.
Yeah, but that's where you can refile on them and say that they didn't legally put their statement in here, so their filing is what do they call that? Stricken from the record.
Yeah. Well, that's their way of hiding the evidence. That's the way. In other words, they knew they had lost, so that was their way of withholding evidence from the court and da 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 da. I mean, that's all part of their BS bullshit.
Yeah.
Well, they're getting terrified because they are realizing that we, the people, are really waking up.
Well, Ed, look at how they reacted with the instrument that I helped you put together.
Well, we're going to get that one, but I'll do what you've done. But we don't want to get in too much because the one thing is that go ahead.
They've recently brought sedition charges against the gentleman for going against the state there.
What was the reason? They have to have an actual reason.
Well, he went into Dun & Bradstreet and got the corporate filings for all these officers, and couldn't find oaths of office for the corporate filings under the corporation under Dun & Bradstreet. And he was going to go after him, and he's in prison.
Is Mike still on the call?
Yeah, I'm still here.
Mike, do me a favor. If you can, send me an instant message through Facebook as to your info.
You're going to get a copy of his email here in a minute, so you'll have it.
Oh, okay, thanks. Okay, thanks, Ed.
Ed, could you email me that, too? I won't be able to answer it for a while, but put it in my email as well.
Yeah, okay, I got to remember your email because I just got 500 of them, so.
DanB_R@Yahoo.
Say that again?
DANBEE_R@Yahoo.
Okay.
Yeah, because it's amazing. I mean, Ed and David and I, we get swamped by so many people. I mean, they want our our email, or they want to be our friends on Facebook, and we're like overwhelmed with so many requests. And we have to be careful too.
I've forgotten my Facebook password, so I don't have a problem with that anymore.
Okay.
My suggestion for people who would like to email Michelle, myself, and Ed, if you mail us an email and we don't respond to it, it means we haven't got to it yet. So don't complicate the matter by sending dozens more.
Well, Ed always wants you to send it 3 times.
Yeah, I do that so that way I know who, what, why, and how.
Well, and you know what? Here's another thing too. What I would recommend is indicate who you are, because sometimes we forget because we get so many when we're siphoning through hundreds of emails, and especially in our spam folder. I always tell people
10,000 emails I haven't even looked at yet.
Yeah,
well, I just call you up, Michelle, and tell you I sent it to you.
Yeah, I believe I still
have your number.
Okay, I thought you did. I was going to say I thought I had received something from you before. I couldn't remember, but that's why I tell people put it in big bold letters. Hey, I spoke to you. Remember me on the conference call or whatever. And then that way you jump out at me, when I'm going through my email or my spam folder, and then I go, oh yeah, now I remember, because sometimes I get so many. I mean, like David was just saying, by the hundreds, or by the thousands, and it's like by the time and yet I'm trying to keep up with what I need to do. I mean, we all have lives, so it's like, I get overwhelmed.
I don't know what a life is. I just fight this stuff because when they destroyed my family, I just want to make sure they feel the pain.
Here's something too. Like when you're doing your documents and stuff, make sure you put like count 1, count 2, and you reference under count 1 about where they're violating this, and I don't know if people do that, but I do.
You have to do that. That's what an attorney does. That's the way the courts respond to it. Yeah. And remember, the most important thing is when you're filing in federal court, you have to put your paperwork on both sides on 8x14.
Well, here's one.
You better do it on all the courts, because I'm telling you right now, they just turn the page over to the blank page and they go, I don't see what you're saying.
Mm-hmm.
You failed to state a claim.
Because we're talking regarding the revenue service or the revenue officers as to the revenue agents, meaning the Secretary of the Treasury, which is off of our bonds. If it rings a bell. Here's something. It's U.S. versus Lindsay Springer.
Oh, that's a good one.
Yeah, let me give it to you. It's U.S. versus Lindsay Springer, 08-278, 09 CR 043.
And I think that's where the revenue districts were dissolved, isn't it?
You know what? You're right.
Mm-hmm.
Yeah, because it has to do with
it's a good one.
Because it has to do with
without the revenue districts, they have no authority.
Right, and that's where they've been putting these districts in, the same structures as the EU under democracy, and people don't know the difference because we have 260,000, or was it 26,000? 26,000 new districts just in the last 12 years in the United States, in your local area. When people have voted, because I don't vote for any of this stuff, I don't vote. I don't participate in the devil's game. And they know it because it's been publicized too. But I don't do that, because when your local levies are passing different things, they'll pass it as a district, and people don't read the fine print what they vote for. So now it's a district, so you're giving them free money access, all right, to your accounts. Remember, they write everything off. When you go to jail and stuff like this, they bill the local taxpayers under the county structure on the birth certificate bonds for the jail. And don't forget, these jails are privately owned.
That's right.
Right. Well, it has to, what I just referenced to you, U.S. versus Lindsay Springer, has to do with without revenue districts, there is no legislation of authority. The revenue officers or revenue agents are not the Secretary of the Treasury.
Oh, Dave, you got to hit that one. Who is the only one allowed to collect taxes? Dave, you still there?
Yeah, I'm here.
Who's allowed to collect taxes?
The IRS, is it?
I thought it was the Secretary of State is the only one allowed to collect taxes.
That is correct. That is correct.
Actually, the Secretary, if the IRS were actually legitimate within a union state, the Secretary of the Internal Revenue Service.
Right.
Mm-hmm.
And so it says more
under 26 IRC 6331A. And that would only be his authority to collect on officers, agents, elected officials.
Right.
Registered church members and immigrants.
No.
That's part of the IRS code itself.
Well,
it also says here, as to U.S. versus Lindsay Springer, it says states, with the capital S, of course, state rights now, treaties do not supersede the Constitution, meaning the Federal Reserve notes.
And you can't pay debt with debt because the Federal Reserve note is a debt.
Because they're all unconstitutional.
It's unconstitutional.
I think everybody needs to read
for the federal
that.
government. You cannot create debt for the federal government.
Mm-hmm.
And then it goes on to...
I think everybody needs to read Article 1, Section 8, Clause 17 of the Constitution. Examine it, see how that's been twisted and frauded to bring all us into those districts. And that's
Well,
where
that's
that zip code comes in, and that's 2-letter abbreviations.
Right, and that's what the lawsuit. That's a case law that I just cited to you. That's exactly what it's in referencing about, because it's unconstitutional. And it's as of Article 1, Section 8. And that's what they're talking about.
I'm going to give you all a good case here, so you guys comprehend this. And I try to put this in all my instruments.
Mm-hmm.
It is, hang on a second, federal judge rules, government debt is covered by, hang on until the screen's up, because my computer's been blacking out on me tonight for some crazy reason.
Reduction Act, Ed.
Yeah, I know. And this goes, the Paper Reduction Act, too. And this goes by, this was published December 18th, 2014. Judge rules that all government debt, that's your property taxes, anything that they want to levy, is covered by the FDCPA Insurance Fund. That is Deb versus Alliance One Recovery Mortgage or Management.
Yeah, and you know what? That's why, and because of that, what the banks have done regarding all those foreclosures are all illegal.
And this falls under Section 1692, parenthesis 4, and 1692E, parenthesis 7. That's where it classifies in it, you know, and then the plaintiff and tracking code, that is 1692, 6 and 8.
Right.
So anyhow, you said your piece. Let Mike finish up his, and then Dave, or I'll finish mine, and then Dave, let Dave have the closing.
Yeah, sure, no problem. I think we actually did. I actually gave you guys the floor, but go ahead.
Well, you know how it happens sometimes, we
got back on.
Nobody gets sidetracked, Michelle.
No, we didn't get sidetracked. We actually started another conversation.
You know what I meant.
Yeah.
Anyhow, Mike, go ahead.
Thanks. On Facebook, one of the pages that I have is called Can Law. And if you go through the file section, it's got a lot of different templates and paperwork you can use that you won't see in anybody else's workout. Interesting.
Okay.
And then violation of rights warning notice, that's one that you want to look for because it covers it's Title 42, 1983, and sections Title 18 U.S.C. 241, 242, 245, and it explains into them. So I'm putting together a package with Ed and a couple other people on rights to travel, and that's with some plates, and that's going to be a form that you'd be able to hand to the cop in a traffic stop when you request your ID. If there's no injured party, if he's detaining you without cause, you can some of the crimes.
Yeah, and we're working on putting a template up too, so that way you can file it with the Secretary of State and the county clerk. And I always suggest what I do is I registered, certify my stuff to the Secretary of State and the county recorder. Then I would fax it in when I had my fax machine. But seeing I don't, I'm emailing it in, and I've already talked to them. They're waiting for my next filing, and Michelle knows what I'm talking about, and they're freaked out because they don't know what I've got in stored. As one of the clerks said to me, you know, we're nervous about you, Ed. We don't know what you got in store. And it's like, you know, the point is that we have to start doing this correctly. And the other point that I keep putting up is like the other cases we're starting to assist in. Remember, we are not lawyers. We are not attorneys. We do not give legal advice because we are not citizens. I am not a registered citizen. All right. I am a lawful American as filed, and as filed a lawful bloodline American. You know, because I mean, I've done both of those filings, and Dave has done both of those filings in our filing, and that goes back, what, 3-4 years now? That you and I have both tag teamed it in?
Yep, we're going, it's unbelievable how time flew, but yeah, we've been together about 3 years now.
Well, that's 4.
Mm-hmm.
Well, I regarding what you're talking about, the statues as traveling and da-da-da-da, I actually applied quite a few of those in Ed's document, so I don't know when he is going to be sharing that with you, Mike, but
Mike's already got it. I already sent it to Mike.
Oh, did you send it? Oh,
yeah,
okay.
That's only being shared with Mike and Dave right now. We're not going any further until I get stuff served, because we have such opposition right now with the so-called lawful American solution people that are trying to take our work and run with it. And not only that, they're trying to take mine and Dave's book. And so, that's been publicly filed. And I will state again, we do have it in contract. So, like what Dixie was saying, you have to prove this stuff. I don't have to prove anything to you people. I have to prove it to the Supreme Court and the clerk.
That's right.
And that is a fact of law and statute. So anyhow, I'm sorry, Mike. We didn't mean to interrupt you. Finish up, Mike. I'm sorry.
Oh.
Well, Mike, I'm afraid I started to write and my pen ran out. But
I'll send you his stuff, Michelle.
But yeah. So, because I would like to see that. You mentioned the one regarding the
yeah, we'll get that to you here in a few minutes, Michelle.
I have seen it once before, but I'd like to see what you have, because, anything that we can come up, any kind of a document or format that we can come up with, right, as to the instrument.
Well, I'm trying to...
Let the man finish up for the night, because my battery's just about ready to run out on my fourth phone.
Go ahead, Mike.
Oh, let's get this thing ended up, because I'm going to be dead in a minute.
Okay.
All right.
Your phone will be dead, not you.
Well, that's what I meant.
In my opinion, the pro se complaint in a federal district court is the most powerful thing you can do if you know how to file it correctly and look through their legalese bullshit and the bar attorney corruption. And I believe I've not completely perfected that process, but we are well on the way to proving it. And we have a complaint for ineffective assistance to counsel filed in Washington State Federal District Court right now. And the first two magistrates assigned to the case have both recused themselves one after the other without stating why. But it's because we excluded them from the contract for being members of the bar.
Did you also bring in the fact that that's a violation of the Paperwork Reduction Act?
This conference is being recorded.
You and put you in prison.
Because you're the surety. They're using the surety because the people have been collateralized. So you spend money. But
that's the bonds, use up, and commodities fraud they're using against you.
So, yeah. So basically, you have to find the paperwork that relates to your rights, and you have to direct the court through your writings and instruments. And I'm finding a lot of good stuff that we've been putting together. And
yeah, you know what, Mike? We have to. The three of us need to have a conversation, because you just touched on something that I'd like to talk to you too, because that also.
Anyhow, we got to wrap this up. Our time is running out on the structure here.
Wrap it up, Ed. Wrap it up then.
I'm letting Mike finish, and then I'll finish, and then I'll turn the floor over to Dave.
Mike, bring this up on our next call. If you're going to be here, let us know if you'll be here. And bring this up on the next call, and we'll try to get Michelle's stuff in and your stuff in. I mean, that these two things are going to be a slam dunk.
Yeah, well, you have to prove fraud upon the court, basically, and collusion with the officers in combination. And that word and phrases books is really important, because combination will show you the index to every.
Hang on a minute, I gotta mute this guy out a minute.
That's all for tonight.
As I can find it.
Well, Mike, what I was going to say on that, what you just brought to what you just mentioned, and of course we can close, but and that has to do with the patents.
Right, we'll get into that, because that's another way of going through court too.
Well,
anyhow, I want to end this up, because we've got to end this up. Anyhow, Mike, we'll see you next week. We'll get. I just sent you guys some information. We'll go there. What's just passed on. Anyhow, I want to thank everybody for joining us, taking the time to educate ourselves by each other, because the only way we're going to make the change. Go ahead. Oh, the light went off. That's why I was trying to find a mute button. But anyhow, we are not lawyers. We are not attorneys. We do not belong to the de facto system, and I do not recommend, and I stay away from the structures of the IRS forms. I stay away from the national foreign registrations and all that, because, there's going to be some conflicts that are going to be showing up, that with a lot of people showing up. And so the whole thing is about proper education about one another, about how we are proceeding in our court cases. The main thing is the education that we're passing on to each other. So when we do this, and so I will be posting some further information up on our sites, okay, and so for everybody to look at with some of the questions we're asked tonight. They will be on the Facebook sites, and for the others, we'll email them, and so we'll get that working. Anyhow, I really would like to thank everybody for joining us. Without you starting to do this and pass it around with your friends and neighbors and Americans and lawful bloodline Americans, I don't have a problem with immigration, as some people have attacked me on the internet saying I have a problem with immigration. So long as they come in legally, there is no amnesty for anybody who showed up on the shore. That's a fact. And that has been proven in Congress, and that's why we're waiting for the maneuver to happen with the new acting corporation president. And the one thing is, I realize he knows what a corporation president is. That's true. And, it's like, I keep having fun with these guys, keep trying to attack me about, the thing about lawful bloodline Americans. And it's like, just because you guys have never read the immigration laws yourself, you don't understand what the immigration structure was coming into our country. This is our country for our family, so that way we survive, we live, and our bloodline is passed. We don't have a problem with legal to lawful immigration, but the point is that 20 years, no, and we've had lawful Americans here ever since. Just because the democracy people that come in, invade into our country, think that they have certain other rights that they could dictate to us. No, like me and David said, and others have said, you're entitled to have your opinion, but you're not entitled to instruct us how to live on our shores. Anyhow, Dave, the floor is yours. We'll wrap this up, and may the Great Spirit walk with you folks.
Well, I'd like to welcome our new guests, the first-time viewers or listeners. I hope that this was quite an educational experience for you, and please come back again. Your comments are always welcome because this is an open mic situation. Your views are important as anyone's, so we encourage you to join the conversation. If you can add something to it, we don't know all the answers, and that's the reason why we're here. We want to learn as much as we can from our listening audience. So if you have questions, please bring them forward. There is no such thing as a dumb question. So again, thank you for joining us. Have a Merry Christmas, everybody.
When is the next call?
We will be back on Monday following Christmas. So have a joyous day and enjoy the family.
Cite the time.
So with that in mind, our call probably next week will be shorter, hopefully.
So 5 p.m. Oregon time, 7 p.m., 6 p.m. Mountain, 7 or Mountains change, 7 p.m. Mountains in Standard Central, and 8 p.m. Eastern.
Right. So that being said, thanks again for joining us, and till next week, this is Dave and Ed saying good night.
Good night, everybody.
Night.
Good night.
Good night. All righty.
Okay, Ed, I think you can close
Your
it out.
conference recording